I beg to mention item 51.
51.
Yes, my lord. It was regarding some dispute, my lord. Within the matter is under amicable process of settlement, my lord. So I may be allowed to withdraw, my lord, with liberty to refile.
Item 51, at the request of learned counsel for the petitioner, stands dismissed on withdrawal.
With liberty time.
The learned counsel for the petitioner submits that there are certain errors which is left in. Therefore, like to refile the same with corrections. Liberty accordingly granted. 51.
Yes.
Writ petition along with IA.
Yes.
Writ petition along with IA dismissed. And interim orders, if any, stands vacant.
Yes, Mr. Lordship, I read for listing a motion of contempt matter, my lord. Actually, fact is, my lord, on 27/5, the matter was listed before the court number 23 without showing my name, my lord. And the honorable court was directed to list after 4 weeks, my lord, without issuing any notice, my lord. On Friday, my lord.
Not Friday, next.
Monday, my lord.
Fifth.
Fifth. Another for admission, my lord. The last posted, my lord, 29/4. Published.
May please your lordship, I beg to mention the matter of writ petition civil 5817/2023 and writ petition civil 5820/2023, which was lastly listed on 18/1/2024, kindly listed on 3rd June.
Not on 3rd. Let it come on
5th. Much obliged.
May it please your lordship, after mentioning for listing of a pending writ petition, lordship, relating to eviction order challenged by the petitioner, lordship.
Obliged. I would like to do two writ petitions. One is non-payment of family pension due to deduction of 6 years, and one is compensation of that.
May please your lordship, I beg to mention for admission, my WBC number 1.
what is the subject matter?
Ex gratia, my lord. Ex gratia compensation, my lord.
Ex gratia. All right, 5th June.
Listing or petition, Lord.
For
Monday, Lordship.
what subject matter?
Lordship, related to some releasing of some articles from the PS, Lord, police station. On Monday, Lordship.
Fifth.
Lordship.
May please your lordship, I beg to mention for listing of a writ petition for admission.
For admission.
Aye.
On 10th.
10th.
Yes.
May-
Please, your-
Yes.
Please, your lordship. Lordship, item number 7 and line, lordship. I am supposed to file an additional affidavit to bring on some records, lordship. Lordship, due to poor electricity connection, lordship, I could not file it. I have filed it today, lordship. So next week, any date, lordship.
7 and 9 to be listed on 5th.
Okay,
Along with the
lordship.
affidavit stated to be filed
Yes,
by the
and lordship,
counsel
item
for the
number
petition.
6, lordship. I am withdrawing. I shall pursue the earlier writ petition, lordship, which was dismissed for non-prosecution, lordship.
7 and 9 to be listed on 5th. And along with the affidavit stated to be filed by the petitioner, registry to trace out the affidavit and connect it to the writ petition. Item 6, the request to learned counsel, same stands dismissed as not pressed.
Deeply obliged, lordship.
May I please your lordship, I beg to mention item number 42. Lordship, allow us 2 weeks time to file our affidavit.
42, you are for the respondent.
Yes, lordship.
Who's for the petitioner?
I'm for a petitioner, your lordship.
Who's for the respondent? You are for the petition.
Petitioner.
Any objections?
No, your lordship.
Item 42 at the request of counsel for respondents, matter stands deferred for to be listed after 3 weeks.
Your lordship, interim order will come.
Interim order passed early will continue.
Deeply obliged.
May I please your lordship, I beg to mention item number 43, lordship, with the consent of the other side. Kindly, it may be passed over just for today, my lord.
Item 43 at the request of counsel for the petitioner passed over to be listed next week.
Obliged.
To be listed after a week.
May I please, lordship, an additional affidavit filed in item number 57 may be called for.
Let it get listed some other day.
Yes, it can be, lordship, Friday.
Item 57 to be listed next week.
I have to inform the council for the petition. I will inform. I will inform.
Be listed. Item 57.
57,
Oh,
lordship.
that's for motion.
Motion.
Okay, then wait.
Yes, lordship. Maybe call for, lordship, I have filed, yes.
So we'll see. You
Lord.
can pass it on to the court.
Lord.
Yes.
Lordship.
Yes. Okay. Yes.
Your Lordship, this was regarding the appointment of independent arbitrator in the contract matter. And in the last hearing, I didn't bring the contract agreement. So this time I bring it to show that condition
No,
70
you'll have
of
to bring it on record. You have to file it by way of an affidavit.
It is 200 pages, sir.
What can be done?
Look, this particular page has been included in the petition, sir.
You see the contract, you see the provisions of the act. You'll have to bring it. The contract agreement or a certified copy thereof has to be produced in court, means it has to be brought on record by way of an affidavit. That is the rule.
I think on condition 70 is the page is enclosed here.
That is not the rule. You'll have to bring it on record.
Sir, give me 15 days time after.
Counsel for the, the petitioner in person, Mr.
Sanjay Sharma.
Sanjay Sharma, submits that you'd like to bring it, the agreement, arbitration agreement. You'd like to bring the contract agreement, is it?
Yeah.
Arbitration is separate or it's a part of the contract?
Part of the contract, condition
Contract
70 is
agreement.
enclosed.
Contract agreement containing the arbitration clause on record by filing an affidavit, he prays for 2 weeks' time. And with RDB appeals, CTC appeals for the response.
Lordship, one thing I want
Not
to
object to the prayer made. Yes.
in another contract, this under WPC, this contract has been already submitted. And I will.
You want an appointment of an arbitrator, is it?
Yeah,
right?
yeah.
You'll have to bring it on record. Bring it on record. Let it be listed after 2 weeks. Do you want a fixed date?
Fixed date, yeah.
14th of
June.
Matter will be listed on 14th.
Right, Mr. Lordship. Non-compliance of the order, my lord, yesterday at page 10, my lord, and operative part, my lord, page 14, paragraph 9, my lord. In the middle portion, my lord, the jurisdictional deputy commissioner was directed to verify and consider for compensation.
Agreed by the non-compliance of the direction contained in the order dated so passing WBC is going to present contemplation of the file alleging willful disobedience. Issue notice, returnable 4 weeks, steps on respondents by usual course and registered post within 1 week from today. List after returnable date.
Three also same, my lord, only, my lord,
Order,
order date is different, my lord.
page number,
Page 12, my lord, 14/11/2022. And the direction part, my lord, page 13.
same order for non-compliance of the order dated 14/11/2022 passed in WPC 5054. It's on respondent. Same respondent. Usual
Obliged.
course and registered post. Yes.
The last occasion, this honorable court directed us to directed the respondent authority to obtain instructions on 26/4/24 regarding the about the outcome of the sanction letter has been issued by the bank authorities.
Lordship, I'm only appearing on behalf of respondent number 1 only, and regarding annexure F, Lordship. Lordship, may I kindly turn to page number 27, Lordship, annexure 1. Lordship, the
Annexure F.
annexure F, Lordship. Annexure F, the department has relation in this matter, probably that Assam Livestock and Poultry Development Corporation, the respondent number 2 is the appropriate authority to give reply, Lordship, in this matter. Lordship, may I kindly issue notice to the respondents, Lordship.
Third and counsel for the parties. You are not representing respondent two.
Respondent, no, Lordship.
Issue notice returnable 4 weeks. MSMM Kotoki appears on behalf of respondent number 1. Steps on the other respondents by usual court and registered post to be taken within 1 week from today. And to be listed after the return.
Obliged, Lordship.
Lordship, let the matter be taken after some time. Mr. Asbora is on leave.
Hezbollah. After some time.
Make please, your lordship. My lord, here in this case, lordship, the petitioner before the lordship has allotted a land lordship and he constructed a faded house. And now the government is taken in Bharatmala project lordship, but they are not paying any compensation or included by name. Accordingly, I filed my representation, which was already duly forwarded by the deputy commissioner to the additional deputy commissioner, page lordship 24.
Yes.
But nothing has been done, lordship, in my representation also till date. So at this stage, may I pray, lordship, let notice may go, lordship, and in the meantime, let the respondent number, deputy commissioner,
Let them first get their instructions, what
Lordship,
what have they done.
lordship, please.
Revenue and disaster, who's appearing? You are appearing? Please obtain the instructions with regard to the annexure 5, page 24. What steps have been taken? Heard learned counsel for the parties. The petitioner is aggrieved by non-release of compensation in respect of the land that has been acquired. By the authorities. He submitted a representation which was duly forwarded by the. He submitted an application for compensation to the DC, Ojai, who forwarded the same to the circle officer, the Oka Revenue Circle. Stop, however, no further information is forthcoming from the respondent authorities being aggrieved to present recognition of the file. The learned government advocate representing the respondent number 1 will obtain instructions on the say representation and place it before the court. Sir, as Borua appears for number 2. 234. 234. You are the one who's to get. You are the one circle officer. The government advocate, Mr. S. Borua, will obtain instructions. The counsel for the petitioner will furnish extra copy
Lordship, I will have that.
within the course of the week
Lordship,
to enable him to obtain the instructions. That's very important.
any date may be, lordship.
Date. List on 14th
No.
June.
Officer,
I have received my instruction from GMD, Lordship.
Yes.
I will file my affidavit. Since there is no violation of the particular building.
Oh.
Second floor was regularized, third floor, fourth floor given, there TDR is, we have accepted it, and there is no violation. I will file an affidavit now.
Bring it on record.
But in response, this was RTI replied, they have specifically answered that no permission has been granted.
Subsequently, the person is in garden. This is prior to me. I will file it in my affidavit.
Let him bring it on record.
Okay.
Mr. A. Dhor appears for the petitioner. Mr. S. Bora appears.
GMC, Lord.
GMC,
GMC and GMD.
GMC and GMD. Submit that he has received instruction. We'd like to place it on record. The permission is granted against the building which is being constructed.
Yes, ma'am.
That is respondent 4.
Respondent
So,
3, 4 and 5. 3 is the
4,
builder.
3, 4 and 5. He submits that as per instructions received, there is no violation in the construction undertaken by respondents 3, 4, and 5. Let the affidavit be brought on record within a period of 2 weeks.
Let it be 3 weeks, 29.
3 weeks.
Building is already been constructed.
Let the matter be listed on 21st
My lord.
of June.
My lord, can it be on earlier prior to that anything or
19,
19? My lord.
19, 19th.
Yeah, Mr. Lordship. My lord, in this matter, the petitioner land was acquired by the respondent authority without any notice, my lord. And proper.
Sorry, what is your prayer?
My fair person that the deputy commissioner to so cause notice to the direction shall not be issued to the face issues notice to the petitioner and above mentioned dark my lord under section 21 of the right, fair and compensation transparency in land
Right.
acquisition.
We'll issue notice at this stage. Yes, anything to submit?
Notice may be issued.
Heard learned counsel for the parties. MS
DG,
DJN appears for
respondent number 4, Water Resource Department.
respondent number 4.
For 2 lot.
MS Hazarika for
2.
2. Mr. S. Borua for
3 and 5.
3 and 5.
1 is a vague part.
1 and 4. 1 and 4 you are appearing.
No, 1.
Your Worship, I'm appearing for 4.
1 is a wrong. entry.
1, they have
Yes.
corrected by hand that it is water resources.
Yes,
But-
ma'am.
So
Yes, Your
you
Lordship.
make
1.
corrections there, probably it's not there. 1 and 4, DJN. Then, finance, yes. Mr. H. Borua for respondent 6. Since the Learned Council then entered, they have entered appearance on behalf of the respondent, notices the way the extra copies will be in a period of 1 week from today. Matter be listed after the returnable date.
Praise God.
May please, your lord.
Yeah.
Lordship, in this case, my lord, we have filed an FIR, my lord, against one accused Sri Babu Boro. Allegation against him, my lord, is that there are some work order has been issued on in the name of the petitioner, my lord. And the work orders are the fake.
Work orders?
Well, kindly peruse the page 58, my lord. That is the FIR, my lord.
Yeah.
My lord, in the petitioner hearing informant is the representative of this petitioner company, my lord. One Babu Boro, who himself shown as a contractor of BTC area, my lord. The petitioner and the accused Babu Boro has executed an agreement, and as per the agreement, there is a mutual understanding that if some work order will be issued in favor of the petitioner, then 20% amount will be as a commission the Babu Boro will receive, my lord. Thereafter, my lord, once work order has been issued, that is at page 27, my lord. That is from WPT BC Department, Additional District Kamrup. It is issued by Boroland Territorial Council, Kokrajhar, my lord. here I have received the work order to supply some uh, uh, materials, my lord.
What exactly is your prayer?
My lord, prayer is my very limited, my lord. Since, my lord, I have lost the FIR in the year 2020, my lord. Till now is 2024, my lord. They have not filed any charge sheet, not investigated the matter, my lord. It's around, my lord, around of crores of, my lord, rupees, my lord, who are
There are-
scammed by the, my lord.
There are provisions under the criminal procedure for that,
That
for
is-
redressal of your grievance.
That is true, my lord, but there is this, the amount is a very huge amount, my lord, who have scammed with the, my lord, government officials, my lord. To the petitioner company, my lord, they have received the materials, but they have not released the bills, my lord. Upon inquiry, I came to know that there
What
is
is
a
your prayer?
fear, my lord, to investigate the matter.
It's already there. You take recourse to the provisions available under CRPC.
The direction is to, my lord, transfer the matter to the CBI, my lord.
That's not for the asking just like that. You have to satisfy. On what basis are you asking the investigation to be transferred to CBI?
So there are primarily some materials against the, my lord, accused, my lord, and the investigation also, my lord, lapses.
No,
due
but
to-
have you approached the proper authority under the criminal procedure that there is a delay in investigation? What is the status? What has happened? Have you approached? No.
No, my lord, before the trial court, I have not approached yet, my lord, that is.
You straight away
I have-
come before the court asking that it should be handed over to CBI. Why?
But on several occasions, my lord, I have approached the investigation agency, my lord, they have not done anything till date, my lord.
But you have remedies available.
That is under section 156(3) is there, my lord.
Then why have you not taken record?
Since, my lord, there is a lots of, my lord, it's a crores of, my lord, matter is engaged, my lord. And the government officials also involved in this, my lord, issue, therefore, my lord.
Whatever it may be, but you file applications under the appropriate section.
My lord, only direction to, to the authority to investigate the matter expeditiously, my
But
lord.
without getting any input, why should we issue? Therefore, we asked you
My lord, I have,
to approach the competent authority.
yes, my lord, I have enclosed the invoices where I have sent the materials to the, my lord, BTC, my lord, the department, my lord.
We have given you enough hint.
I will be giving liberty, my lord, to approach before the appropriate authority, my lord.
Learned counsel for the petitioner seeks liberty to withdraw the petition and approach the competent authorities prescribed under the criminal procedure code. Liberty granted. The petition accordingly stands dismissed. Roll. Needless to say, if the petitioner is still aggrieved, he may approach this court. We have given you liberty to approach.
My lord.
If after approaching the authority, you still have grievance.
My lord, I'm deeply obliged.
May I please, Your Lordship? In this case, Your Lordship, the husband of the petitioner had expired due to road traffic accident, which took place on 09/07/2022 in public place and public area, Your Lordship. And after that, Your Lordship, petitioner sent an application to the District Commissioner of Bishwanath District with a prayer for grant.
We need to notice here, heard.
Yes, Lordship.
Counsel for the parties issue notice written about 4 weeks. Mr. A. Bhattacharya appeared for respondent 1. Mr. Yes. What is your name again?
RM Barua, Your Lordship.
I am
RM Barua.
RM Barua appears for respondent number 2. Mr. S. Barua for respondent 3, 4, 5, 6. Since the councils represent the respondent, notices are waived, however, if the public is within a period of 1 week from today, matter be listed after the referendum.
Lord, deeply.
May I please, Your Lordship? Lordship.
Lordship, petitioner here is, my lord, is a widow, my lord. Her husband died in the year 2023, 24/8/2023, my lord. After the death of the husband, my lord, petitioner received one legal notice from the respondent bank, my lord, State Bank of India, saying that, my lord, petitioner's husband took one loan of 7 lakhs rupees, my lord. And that account was NPA, my lord, become NPA on 30/8/2023 after the death of the petitioner's husband, my lord. Thereafter, my lord, petitioner submitted one complaint, my lord, as page 21 is the status of that complaint, my lord, before the financial service of that State Bank of Banking Division, my lord. My lord, surprisingly, on the next day itself, page 22, my lord, lordship may kindly see, page 22. This is the reply they have submitted against that our complaint, my lord. The bank authority, my lord, illegally hold up the salary account of the petitioner, my lord, without any legal proceeding. Petitioner have two sons, my lord. They were students, my lord. One is 19 years old and 24 years old, my lord.
There is a standing instruction
My lord,
signed by the late husband.
yes, my lord. That was only authority letter to withdraw his money, my lord. But as his husband was expired, that authority letter become infructuous, my lord. Because during the lifetime only, that authority letter will work, my lord. And now they are holding up the salary account of the petitioner, my lord, not husband's account, my lord.
Petitioner is also working.
Yes, my lord. Petitioner, my lord, page number 15 is the identity card, my lord. Page number 15. Petitioner is working as a enforcement checker under the transport department. So it's not a case that we are not willing to pay, my lord. We are very surprisingly know, my lord, that there were some loans. Now we want to repay, my lord, but not like this, my lord. Because it's a livelihood, my lord.
What is the loan amount?
Loan amount as per them, my lord.
7 lakhs.
Originally it was 7 lakhs. Now with interest, it's become 4 lakhs something.
It become?
It's become, my lord, 4 lakhs.
After payment of certain amount.
Yes, my lord. They also included the interest amount also, my lord.
You serve copies on the SBI.
We can serve, my lord. Otherwise, they don't have any standing counsel. That is why, my lord, panel lawyers are there, my lord. I can
Heard learning counsel for party issue notice. Returnable 4 weeks. Steps on respondents. All respondents by usual post registered post within 1 week. Matter be listed after the returnable date.
some protection, my lord.
What
Interim method.
protection?
My lord, because this is totally illegal, my lord. They cannot hold up my salary account, my lord. It's my livelihood, my lord. At least some person, maybe, my lord.
What is the amount standing in your account?
Hardly 2 lakhs, my lord. That amount, my lord.
Therefore, you should have served copies. You serve copies, we'll take it up again. We'll make it returnable by 2 weeks.
My lord, I will serve, my lord.
You serve copies,
Yes,
then we'll hear.
my
Ask
lord.
them to
That
come
can be
with
done.
instruction.
My lord.
Matter be made returnable within 2 weeks.
Date may be fixed if possible, my lord.
14th June.
My lord. Highly obliged, my lord.
My please, Lordship. My lord, my GST was cancelled, my lord, without granting an opportunity of hearing, my lord. Lordship will see the order at page 31, my lord.
Yes.
My lordship will see the reason he has given, my lord, that for the following reason, section 29 to C, person other than paying tax under section 10 failed to funds return for prescribed period, my lord. And your lordship will see the focus notice at page 29, my lord. The
charge is different, my lord. There is a allegation of violation of rule 21A, my lord. A person does not conduct any business from a declared place of business, my lord. Moreover, my lord, section 29 requires, my lord, a hearing, my lord. That was not affordable to petitioner, my lord. And lordship will see the so cause was issued by respondent number 3, my lord, and the order was passed by respondent number 4, my lord.
Who is respondent 3?
Respondent 3 is the assistant commissioner, my lord, and respondent number 4 is the commercial tax officer, superintendent of taxes, my lord. Moreover, lordship, I have submitted my reply at page 30, my lord.
Yes.
The requirement of law, my lord, before cancelling, my lord, they are incumbent to, on their part to, my lord, provide the opportunity of hearing, my lord. And my lord, they have also traveled beyond the scope of so cause notice, my lord.
Yes, the ground is that you did not conduct business.
Then lordship will see that it was allegation in the so cause notice, my lord. And the reason of cancellation, lordship will see that I have not furnished the return, my lord. I have been conducting business, my lord. I have a trade license, I have a rent agreement, my lord. That I have stated in my reply at, my lord, page 30.
Yes, Mr. Gogoi.
My lord, here, my lord, so far as this discrepancy that he has pointed out, I will have to see this first, my lord, because
Get instruction.
yes.
Let him get
My lord.
instruction. Third learned counsel. Will issue notice then?
The lordship, if it can be for instruction, my lord,
Yes,
otherwise
I let me have the instruction, my
All
lord.
right.
Why, my lord?
Mr. P. Gogoi, learned counsel appearing for state GST, represents all the respondents. Mr. Gogoi will obtain instructions in the matter by the next 8 days. List on 14th,
my lord.
My lord.
extra copies be furnished to facilitate obtaining
Got it.
instructions.
Deeply obliged. Yeah, please. my lord.
Yeah.
In this case, my lord, petitioner have challenged the show cause notice for which was issued for violation of setbacks of the building, my lord. Building completed in the year 2015, my lord, and petitioner already submitted his reply, my lord. Your lordship may kindly peruse page 53, my lord. That is the improved show cause notice.
50?
3, my 5K.
Hmm. Bolo. Ah.
My lord.
Yes.
My lord, it has been observed that you have grossly violated the permitted NOC condition of this authority in terms of the setbacks at all the forced site during construction of your RCC building. So you are hereby asked to propose within 7 days from the date of receipt of this notice as to why said authorized construction portion should not be demolished as the same is beyond NOC permit condition. Also,
Where is your permission?
permission is at page, my lord. Page 43, my lord. Type copy is page 43, 44 is the original matter. Original is. And also development authority also permitted me to construct the building method. It's the development authority. And I have also submitted reply method. Then there is no mention about how I have violated the setbacks method.
Yes, then.
I have, in terms of the short course method, I have submitted reply at page 55 method. Your lordship 54 starts from page 55 method, relevant para is page 6, para 6 method. May I read? That although there was
what
no
order has
violation-
been passed thereafter?
My lord,
Where is the impugned order?
impugned order is the short course notice method.
Only show cause notice.
My lord.
So why have you come against the show cause notice?
Well, after submission of reply, my lord, that is my apprehension that they may demolish my part of my building, my lord.
They will have to pass some order.
They have not filled it, they have not passed
They
any
may
order.
not have, but show cause notice
And after I have also submitted the reply, my lord. My reply page, para 6, my lord, your lordship, I have
Yeah,
clarified.
who's for the respondents? Silchar?
In fact, I think as Dasgupta appears for the Silchar manifesto as well. Opinion, as Sishila.
Yes, sir. In that case, I will serve in a copy. I don't know.
You serve copies
It may be come up on Monday, my lord.
Monday, all right.
Today I will serve it.
Matter be listed on Monday next, by which time the counsel for the petitioner will serve extra copies on the counsel appearing for the Silchar.
Means, Obliged.
Similar order, page
Act of God,
50. Extension of
force majeure.
Force majeure.
force majeure.
Where is that order?
Page
81.
number 80.
But I am yet to comprehend when there is a challenge to the virus.
Lordship, that is the problem. Lordship, what happened? They have challenged the notification, whereby the limitation has been extended. So the matter come before different courts. Court number 17 dealt that this is since the virus has been challenged, so it will go to the division bench. But court number 12 held that no, since it is a subordinate legislation, so single bench can take up.
Yes. Prima facie, it appears to be a subordinate legislation.
Yes, sir.
All right, heard learned counsel for the parties. Page number 81. Take steps. Yes.
Milord, the report which was submitted by conducting a ground verification in presence of all the stakeholders, this is relating to preparing an award of the land which has been utilized by the railway and which were under the occupation of the petition. In the earlier round of litigation, this honorable court directed that it should be looked into, and accordingly, award should be prepared and it should be submitted. And that verification was done. But ultimately, the deputy commissioner, without confining to the report, ground verification report, he has included some more areas which were never utilized by the railway. So railway was also present in the ground verification. They have raised objection. Now the matter is hanging. And the deputy commissioner, we have filed representation that you correct it. This is where from you got it. This was some attempt was made to make some gain out of it by some people. Therefore, they having failed to get any response from the deputy commissioner, they are before your work. We want virtually the deputy commissioner to decide it. He should look into and decide it, taking our representation. Meanwhile, Lordship may issue notice, let them come and say, if necessary, Lordship will then direct, after hearing them, that they should look into and correct it.
Yes, anything to submit, Mr. Talukdar?
I'll take the exception.
Will issue notice.
Well, yes.
Heard learned counsel for the petitioner, issue notice. 4 weeks. Mr. B.J. Talukdar. Counsel represents the Revenue and Disaster. Appears on behalf of the
4 and
Revenue and
5.
Disaster Management
Only
Department.
4 and 5, huh? Go ahead.
I appear for 1. Oh, you are appearing for 1, sorry. Mr. A. Bhattacharya appears for respondent 1. Who's appearing for NF Railway? Any standing counsel? Railway?
We'll start copy. Who is there?
Notice to respondent number 2 by registered
NF Railway.
Lady.
He's appearing.
2 and 3.
Okay, I'll appear for that.
Mr. D. Das appears for respondent 2 and 3.
2 and 3.
And MSM Bourbon assisting Mr. B.J. Talukdar.
For 4
Senior
and 5.
counsel appears for 4 and 5. And MSM Bourbon, government advocate assisting Talukdar accepts notice.
2, 3.
Since the respondents are represented, notices are waived, however, extra copies will be furnished within a period of 1 week. Respondents are at liberty to complete their instructions and file necessary affidavit if so advised in the meantime.
The returnable lordship has made. Returnable.
Yes, after return, we have not fixed the date. You want a date? You want a date?
Lordship may fix it so that authorities will be alert that.
Will, in July?
Yeah.
The matter be listed again on 17 July.
They'll serve extra copy. 17
Serve
may be,
extra
yeah,
copy.
17 you have Bandhavan.
No, no holiday.
July,
No holiday.
Yeah.
17 July.
July, yes. Okay, my lord. Wednesday, apply.
Yes.
It's the same order, Lordship. It's
Huh?
already passed, Lordship, that challenge has been made to the Lordship notifications, extending the time limit of the,
Force majority.
which we have already passed similar orders, Lordship, on Monday.
But COVID, is it not a part of force majority? Prima facie, it
It's
is-
so long over, Lordship. The notifications have been issued now.
okay. Hard land accounted for parties. Notice. A matter of 11. Item 16, similar. Yes,
Much obliged.
Mr.
For
Chowdhury
three and
for state GST and
1, 2.
Mr. Gogoi
Yes.
for 1 and 2. You are for union,
Yes. Yes.
GST. Yes.
Much
Yes.
Same, my lord, as earlier also, you should notice, my lord, same this, they have held land under riot, my lord, which has been taken over by the government. And even after taken over the government also, they should be recorded as a tenant under the government, my lord. This is the law. Notice may be issued, my lord.
Hard land accounted for the parties. It's written about 4 weeks. MS.
As for number 1, Lordship.
APS for respondent,
1.
1. And who's, any other government advocate?
Government advocate will appear.
Mr. R. Dhor, appears for respondent 2 and 3. Mr. Dhor, we are recording your name for 2 and 3. Respondents 2 and 3. Since councils appear, notices are waived, however, extra copies will be furnished within a period of 1 week from today. List recording.
Deeply affected.
My lord, the respondent, my lord, has filed additional affidavit today itself. My lord,
It's not on record, so let
yes,
it
not on
come
record.
next week.
So, my lord, we need to reply this affidavit, my lord.
All right.
So, let it be posted after 2 weeks, my lord.
Okay. MSR Bora, Learned Council appearing for NHI DCL.
That's number 3, Lord.
Respondent 3 submits.
Additional
You have filed, what have you filed? Additional affidavit?
affidavit, Lord.
File an additional affidavit today. Same, however, is not correct. Case record. Mr. M.E. Mondal, Learned Council for the petitioner submits that he has received a copy. He would like to respond by filing like either of
Yes,
next time.
You do not have to clear it.
Let the matter be listed again after 2 weeks.
Wait, so you're working.
You are appearing for someone?
For respondent number 1.
Ms. K. Pugar for respondent number 1.
Appearing for RDP.
For
আইবা আহিছে দেখোন কেনেকে আছে অলৰেডি বুঝি যোৱা
MS D. Azorica for respondent number 4.
হৈ আহিছে ডাবল ডাবল নাই
List the matter again on 21st. 21st.
Publish.
21st June.
Till then, my lord, the interim order may be.
Interim order to continue till the next date fixed.
Development.
25. Yeah, oh,
Yes.
Lordship, this writ petition is about the acquisition of land. Without awarding compensation, land has been acquired. But in the parent writ petition, the executive engineer of the PWD department as well as the water resource department implicated as a party. But unfortunately or mistakenly, the authority, chief engineers of both the department are left out. So if any order is passed, it has to be directed the authority.
Any objection?
No, Your Lordship.
Heard learned counsel for the parties. This IA has been filed with the petitioner, praying for implement of chief engineers, chief engineer water resources department, government of Assam, and chief engineer irrigation department as party respondents. The learned counsels representing the water resources and the PWD department does not object to the prayer made, as well as the government advocate does not oppose the prayers made. Accordingly, the IA is allowed. The respondents, opposite parties 7 and 8, namely the Chief Engineer Water Resources Department and Government of Assam, Chief Engineer PWD Department, Government of Assam, are arrayed as party respondents. Number
7.
Seven and
7 and 8.
7 and 8.
Yes, Your Lord.
7 and 8. IA accordingly stands allowed and disposed of. Writ petitioner to file amended post title in the registry within 1 week from today. Insofar as writ petition is concerned, in view of the order passed today in IA number so and so are arrayed as party respondents number 7 and 8. Stop. The councils, standing councils representing the PWD and the irrigation department respectively also accepts notices on behalf of the chief newly implemented respondents. Have you filed any counter? Someone has filed?
Not yet, Lord.
The respective departments may complete their instructions and file necessary affidavit in the meantime. Matter be listed in the month of July
Lordship.
after reopening. Yes.
Nice.
Can I prefer date?
17th July.
But
Yes.
this is a matter where a particular land was allotted in favor of this organization for construction of a Gandhi Sangrahalaya. My Lord, apparently, in terms of the affidavit filed by the District Revenue Authority, there is an encroachment by the other petitioner. Now, my Lord, that the other petition, because there was a move to evict the other party to hand over the land, they also approached this honorable court by way of the other writ petition, that is 1236 of 2017. Now, they claim to be some Madrid committee. My Lord, this is neither a registered body. How can they maintain a writ petition? Therefore, in my humble submission, this 1236 of 17 needs to be rejected outrightly. They can't maintain a writ petition, my Lord. And they are, my Lord, encroachment. Now, if your Lordship would kindly take this 463 of 15, that is our basic case. In that, the then circle officer had filed an affidavit where they have clearly taken a stand. Your Lordship would kindly take the affidavit of the circle officer, Guwahati Revenue Circle. It is filed by one Damodar Bormon.
Yes.
If your Lordship would kindly come to paragraph 5 of that affidavit, 5, 6, and 9. That as regards the statement made in para 7 of the writ petition, the deponent states that the land was visited by the then circle officer and it was found that there is an encroachment of 2.20 R by Gopinath Nagar Masjid Committee and 7.0 R by other private persons, and accordingly informed the Deputy Commissioner White later at its friends. That as regards the statement made in para 8 of the writ petition, the deponent states
as there was encroachment in the allotted land of the petitioners. Therefore, this office is unable to correct the revenue record. Then para 9, that as regards the statement made in para 12 of the writ petition, deponent stated as per the direction of the Deputy Commissioner, while order dated 24/2/17, an eviction notice was issued by memo dated so-and-so to Gopinath Masjid Committee for eviction from government land, so-and-so, so-and-so. So, my lord, the moment this eviction notice was issued, the other writ petition was filed, that is 1236 of 17. But what is their enforceable right, my lord? You come to writ court to enforce your right. You are an encroacher. So what is your right? You may be a religious institution. Therefore, my lord, my humble submission is, in terms of the allotment, the land should be allotted to us. Sorry, handed over to us, we have paid the premium also. And my lord, this writ petition, the stay order should be lifted. There is a stay order operating, that's why district administration could not carry out the eviction.
In the other writ petition.
Yes.
Yes.
And my lord, in the other writ petition, we have filed an affidavit. If your lordships would kindly have that.
You are implicated as a party.
No, yes. And where we have filed an affidavit raising the preliminary objection. We have said, being an unregistered body.
Next slide.
Only one thing I just wanted to point out before my learned friend continues. In that earlier matter, 1236.
Yes.
I have been newly engaged today. I need to file my wakalat. I was not there in this case. I'm newly engaged, so I would seek for some time, some accommodation. To the convenience of all.
If I have not mistaken, my learned friend had appeared in this case on several occasions.
No, no. In this
and
matter,
on this plea, time was taken.
In the second matter, I am there. In the new matter, my name is there. But in the first matter, I never appeared. In this matter.
No, first matter,
Philosophy will see the call this also. My name is not there. And in fact, I was handling this case in the morning. I have been given this case. So I just need some accommodation. One, 2, 3, 6 of 17.
You are appearing on whose behalf?
For those for the petitioner, Gopinath Nagar Masjid Committee.
Is there a respondent number 4 here?
Yes.
So
I just thought
end of the day,
apprise this honorable purpose.
end of the day, my lord, their case is projected in 1236. Now, I don't think they can take any stand better than the stand they have taken in 1236. Therefore, my lord, what is the? I think this matter has been adjourned for several time, my lord. It's a 2017 matter. Now we are in 2021.
I pray for just one accommodation.
2015. Yes.
I pray for just one accommodation. And I undertake on the next date, we'll dispose of the matter. From my side, there will be no item. I'm in a bit of a difficulty today with the records and the briefs and everything.
So let it be taken up on Monday next month. Monday is 3rd.
5th, we'll keep it for 5th.
Yes, sir.
5th of June.
5th of
Well, 5th, sorry, 5th, I have a difficult. Let it be on 7th.
7th.
Yes.
7th of June. Heard counsel for the party, Mr. A. Sharma, counsel, appearing for the petitioner in WPC 1236, submits that he has been engaged to appear on behalf of the said petitioner, who is also a respondent in WPC number 463. He is yet to complete his instructions. He prays for some accommodation today. Accordingly, he has agreed to by the councils for the parties, matter then referred to be listed again.
7th, madam.
7th of June.
Deeply.
Mr. B.J. Talukdar for state government.
No, Your Lordship. In this case, Lordship, on the last occasion, I was directed to obtain instruction, Lordship, regarding the release of payment law. I pay another 3 weeks time, Lordship. Actually, I received a communication from the department. The process is going on there. They are verifying the list, Lordship.
Yes,
Time,
Another 3 weeks time.
because 2016 matters is one after another time
We
is
will
like,
release the payment after, before that we have to verify, Lordship, because some,
the time fix may be framed, my lord.
further, further time for completing the instruction prayed for by the other government. The other. Mr. Sundar, submits that several opportunities have been granted. The final opportunity be granted to the respondents. to complete their matter stands referred to be listed again on
12th of June.
June. Please complete your instruction. What exactly is the prayer?
For compensation of rupees 50, financial assistance of rupees 50,000 and 10,000 to 70 injured person.
As per my telephoning instruction, Lordship, some payment has been released to the grievous injured person, Lordship. So, Lordship, we have to verify the list, Lordship. That's why I'm paying for more time.
Why don't we close it? You verify and you pay whatever is to be paid. Yes.
So far, my information, my lord, not a single person received the money.
You are appearing on whose behalf?
I am for appeal number
No, petitioner.
1, Lordship.
Petitioner.
Well, all the petitioners' money.
I'm for 1.
53 petitioners. Sir. Where's the final?
I'll come up with Lordship.
You are asking for compensation in respect of which notification?
By
Under which
2012 riot, ethnic riot in Kugrajar, my lord.
That is okay, but is there any notification, government order?
Yes, my lord, it is annexure 1 is there.
Annexure 1.
Yes.
Page 17.
List also sent by the deputy commissioner.
Annexure 1.
Yes, my lord.
Is regarding proposals for sanction of financial.
Yes, yes. Then
pending.
that is not a dispute
This is
by the
pending.
authority.
Before the Revenue and Disaster Management Department, Lord. This proposal.
All right, you get instructed.
Lord.
But we are putting you to notice 2016 matter, we are giving you final opportunity.
Lord.
The respondents are permitted a final opportunity to complete their instructions, failing which the court will proceed to dispose of the matter on the basis of the materials available on record. Matter be listed on 12.
Yes.
DPW. May I please,
Say
Lordship?
all pending matter, my lord, for grant of patta to the petitioner.
I am praying 1 week time for file affidavit on behalf of Rishikesh Sharma, Lordship.
You have
He
received your
is,
instructor.
yes, affidavit also ready, but he is not well, so he cannot come
Whose behalf?
on Rishikesh Sharma, additional senior government advocate.
Okay. Yes,
1 week
Mr.
time.
Singh. MS Borwal and government advocate appears and submits that the affidavit of the respondent is ready to be filed. However, because the government advocate is in this post, the conducting counsel is in this post, the affidavit will not be filed. She prays for 2 weeks further time. Prayer is not objected to by Mr. PKC. Matter be listed again on 10th of 2 weeks on a date to be fixed by the registry. Yes.
May I please, Lordship? Lordship, Impugn letter is on page 22, my lord. Annexure 4, my lord. Petition is a licensee of fair price shops, my lord, having 48 numbers of ration card. My lord. Ration cards of petitioners have been tagged with the nearest ration card 776 numbers of ration card. My lord.
What grounds are you asking for setting aside of the decision?
Lordship, I filed, my lord, one representation, my lord, before the authority, my lord. Annexure 6, my lord, page 22, my lord. I have, my lord, only 2 ration card shorts, my lord. Lordship, authority may be directed to consider my representation, my.
This matter is already covered by by the judgment of some another of this court in WPC 547021. On last occasion, Honorable Court directed to produce the
Yes. What do you say?
Lordship, my representation may be disposed of, my lord. Yes.
No, no, there is a judgment.
Yes, my lord.
Yes, in the face of the judgment, what do you say?
Lordship, my prayer is different, my lord.
I think this is covered.
Yes, my lord. Lordship, but my prayer is different, my lord. Prayer number 3 may be considered, my lord.
Prayer,
Prayer 3 may be considered, my lord.
in view of the judgment, this prayer is not mentioned.
not mentioned.
Cannot be considered.
Only 2 ration card short, my lord. In
How many ration cards you have? 48.
48, my lord.
Okay, hard disposed.
Thank you, Lordship.
We are covering it. We are disposing it off in terms of this judgment. Dismissed.
Most complete.
File. Everyone move that file.
Lordship, there may be Passover for some time.
Can be good.
You're passing it over for the day.
My lord.
Lordship,
Be
kindly
passed
some-
over for the day.
Kindly sometime, my senior is in legs in.
All right, then at second half. Second half.
Yes.
Just, it may just pass over the some mix up in the files. What? इसके बाद तो लगे बहुत ज्यादा कोई दिखा दे कि मैं एकदम नीचे कुछ जम के तुम 300 दिन और कुछ नोटिंग एकू नीचे दिया well at the matter relates to Miller one machine where the maximum operating capacity on the basis of which below the excise has to be levied. If your lordship just looks into because the matter earlier was carried to the single bench and division bench and again the assessment order was passed. If your lordship looks to the list of dates, Miller.
Yes.
Well, in fact, well, in 1904-2013 to 1912-2013, the petitioner in the month of January 2014 purchased a packing machine from Japan for manufacturing of pan masala without tobacco pouched as per the product specification stated in the quotation of the machine below. The estimated speed capacity of the machine was 900 to 1000 pouches per minute. For the month of size below, so the purchase order was also placed for the same product specification. The invoice under the cover of which machine was consigned from Japan. So in the specification, it was say the 900 to 1000 pouches per minute of the said product when the machine was purchased. 19/9/2014, the first declaration, a declaration has to be made to the excise authority that what is the maximum capacity of the machine below. The first declaration was made under the rules by the petitioner on 9/11/2014, showing the operating capacity with effect from 18/1/2014 for pan masala into 20 gram pouches. The minimum packing speed of the machine was declared to be in form 1 as 750 pouches per minute below. The petitioner company intended to operate it below in the speed of the formulated by the so-and-so limited for achieving stability in the quality, which was based upon the speed experienced during the trial of the so-and-so 750. Now, my lord, on 17/1/2009, the declaration was made on 9/10/2014, stating that the maximum packing speed at which the machine could be operated was 750 pouches per minute, was approved by the Assistant Commissioner of Central Excise. So 750 pouches, my lord, the operating was approved by the Assistant Commissioner. The petitioner continued to operate for similar operations
up to June 2014, declaring the maximum speed to be 750 pouches per minute for sealing and so and so. Therefore, on 18 July 2014, the letter of event date, the petitioner company provided another declaration in terms of so and so of the rules regarding a machine to be Assistant Commissioner of Central Excise. The petitioner company stated that with effect from 26 June 2014, the petitioner will be operating the machine with manufacture of so and so with a MRP of so and so per pouch at a speed of 1,000 pouches per minute. Below, the petitioner tried to operate it with 1,000 pouches per minute below. On 13/7/2014, below, the said declaration of the petitioner company regarding speed of the machine was also approved. Thereafter, below, on 1/3/2005, for determination of the annual capacity of the production of unit as well as the monthly duty payable, which was both were directly dependent upon the maximum capacity speed of the machines, was laid down in the three different slabs, that is up to 300 pouches. But earlier it was as per the machine. Subsequently, it was made as per the capacity of the machine, that is 300 pouches one, below 751 and above 751 one rate below. That was by way of an amendment. Now, Lordship, on 24/4/2015, my lord, the petitioner was receiving complaints about the quality of the, my lord, the packing of the pan masala when the petitioner was operating at 1,000 pouches per minute, my lord. And thereby the petitioner company sent a email dated 24/4/2015 to the supplier in Japan that there were several problems in the machine and hence requested for the necessary rectification. The said the supplier, while email dated so and so, informed that they had a meeting with the R&D and the production department regarding non-performance of the machine, and that they had tried their best to deliver the desired speed. However, after many internal meetings, they came to a conclusion that the machine was not capable of running at the speed of 1,000 pouches per minute and would be smoothly at the best at 740 to 750 pouches per minute. The petitioner company thereafter sent a letter to the Assistant Commissioner of Central Excise that at the Assistant Commissioner of Central Excise approval order dated so and so, the petitioner company was to operate the machine from 19th May 2015 to so and so. However, due to number of customer complaints from the marketing relating to the effective recalling pouches, the improper pouch information, the petitioner company had decided to discontinue the operation of the machine at the earliest possible date. Whenever the machine is to be stopped, then we have to inform the Assistant Commissioner and they come and they will reinstall it. And whenever we have to again activate it, then we have to also inform the Assistant Commissioner and their presence only, it is reactivated again, my lord. On 29/5/2015, the Assistant Commissioner passed an order to the letter of the petitioner company approving the declaration of the petitioner company in Form 1 regarding the speed of the machine at about 751 pouches per minute and allowing the manufacturing of the product by the petitioner as so and so. My lord, on 12/6/2015, the petitioner company informed the Assistant Commissioner of Excise the matter with respective speed of the machine was taken up with the supplier, who after a detailed review and admitted that the machine suffered from the major technical snag is designed, and although it was designed to manufacture the size pouches at the speed of 1,000 pouches per minute, but they found that the high-end CPU fixed therein did not synchronize itself with the internal quality checks, etc. It was decided to downgrade the CPU so that it matched with the internal controls and checks of the machine. Hence, the petitioner company informed the Assistant Commissioner that the petitioner company would like to conduct a non-commercial trial run of the machine in the Assistant Commissioner to find out both of 18 grams of Toronto passed. Based on this report, the Assistant Commissioner Central Excise, the order dated so and so, holding that the maximum taking speed of machine falls within the slab of 301 to 350 pouches per minute. So, my lord, the
Assistant Commissioner passed an order that the maximum speed will be 301 to 750 pouches per minute. Now, my lord, the petitioner company, my lord, sent a letter. The respondent sent a letter on 18 November 2015 to the petitioner company, informing that it about initiation of the inquiry in relation to the package size of the machine, and thereby called upon the petitioner to submit a list of documents pertaining to so and so. My lord, again, a fresh inquiry was being conducted. The petitioner company sent a letter on so and so to the assistant commissioner, informing that on so and so, the petitioner would be restarting the production by operating the machine, and therefore the assistant commissioner of Central Excise was requested to deseal the machine on 29/11/2005 so and so, and thereafter to install and seal the machine on 30/11/2015. As declared in all the last declarations in the period from so and so, the maximum speed of the machine was similarly declared 750 pouches per minute, as determined by the Honorable Assistant Commissioner of Central Excise and so and so. Now, 25/11/2015 is important, below. The Assistant Commissioner of Central Excise issued a so-called notice on dated 25th November 2015 upon the petitioner company calling upon to submit regions in defense to establish that the maximum packing speed of the machine was below 750 pouches per minute per pouch per weight, as declared by the petitioner company on so and so. The so-called notice also called upon the petitioner to personally appear on so and so before the authority below. The petitioner company, in response to the assistant commissioner notice below, submitted all the requisite information. 27/11/2015, acting on the high-handed manner and in complete disregard to the law and due process, the assistant commissioner of Central Excise, in a pre-received manner, passed an order whereby it was observed that as per the petitioner company's own submissions, it can be concluded that for 18 grams per missile, the maximum speed of the machine falls in the category of 751 pouches per minute and above an assessment of duty, and not 750 pouches per minute as so and so. My lord, the main, my lord, the issue was that, my lord, that once you have declared the capacity, then you cannot change it. That is the basis which has been taken. Now, in the rule, my lord, every month I have to give declaration, and every month it has to be approved. It's not so that one declaration which has been given in the very beginning, that will be final for altogether. Every month I have to give a declaration, and every month the assistant commissioner has to approve it. Now, in the similar situation, my lord, on you also will find 12/4/2016, the Rajasthan High Court, my lord, having been accepted, my lord, the Rajasthan High Court gave a finding, my lord, that no, the declaration once given is not binding, and it can be, my lord, the month, my lord, the declaration has to be given, and the assistant commissioner has to apply his own mind on the said declaration, thereafter approve it. Now, that Rajasthan High Court decision was also, my lord, accepted by the Central Board of Indirect Taxes, which I mentioned, my lord, that the decision of the Rajasthan High Court having been accepted by the Central Board of so and so, while circular number so and so, the respondent authority cannot be acted so and so. So the said, my lord, the decision of the Rajasthan High Court was also accepted by the, my lord, the Central Board of Indirect Taxes. Now, my lord, against the order, my lord, which was passed by the assistant commissioner, an appeal was preferred before the commissioner appeals. You'll also find in 38/2016. That an appeal was filed against the order dated so and so before the Commissioner of Customs Central Excise. And the commissioner wide order dated so and so allowed the appeal filed by the prisoner and held that the maximum speed of the machine should be production speed of the machine, and the same would be to be determined under Rule 62. It was observed that all the declarations about the maximum speed of the machine were on record, and there was no misdeclaration, and the order passed by the Assistant Commissioner of Central Excise from June 2015 to October 2015 have remained unchallenged and uncontested. It was further held that the order dated so and so was passed in accordance with the prescribed rules, and the physical verification of the machine in the presence of the departmental officers and departmentally deputed chartered engineer, and the said order would not be questioned or the Assistant Commissioner at Central Excise, a partial issue authority, it was held. Below the machine which was when checked, below, then a deputed chartered engineer from the Excise Department was present,
And his presence on the basis of his report, only the pouches were, my lord, the maximum speed was declared. And that was accepted by the assistant commissioner. In spite of the same having been accepted by the assistant commissioner, my lord, he passed an order rejecting the declaration earlier made, my lord, and earlier accepted. Now, Commissioner Customs on that order rejected my lord, reversed the order of the assistant commissioner and said that no, the declaration which was made, that was on the basis of the declaration made as per the report of the chartered engineer of the central excise, and thereby there cannot be any, my lord, reason for the assistant commissioner to again, my lord, say that no, that declaration is wrong. Now, in spite of the order being passed by the, my lord, the assistant commissioner, again a so-called notice was issued. My lord, when the inquiry was going on and summons were issued, we filed a writ petition before this honorable court. And this honorable court, my lord, declared that, my lord, the entire proceedings are illegal and set aside all the proceedings on the ground that, my lord, the proceedings already have concluded and thereby the first proceeding cannot be initiated. My lord, the writ petition, writ appeal was preferred by the department, and the writ appeal was also the judgment of the writ appeal. You will also find they only said, my lord, that the judgment was not, my lord, interfered with, but they said that you can continue with the inquiry without, my lord, asking for the person's presence and all those things. Now, thereafter, again, my lord, a so-called notice was issued, demand on so-called notice was issued, saying that, my lord, why the demand should not be levied on the petitioner on the ground, my lord, that the misdeclaration was made by the petitioner. Now, your lordship may kindly note it, my lord, the earlier declaration which was accepted by the assistant commissioner was never a subject matter of challenge that attained finality. Made the declaration which was made on the basis of the report of the chart.
1,000 pouches.
750.
750.
On the basis of the report of the chartered engineer or deputed by the excise department, he operated the machine and he submitted a report to the excise authorities, and the assistant commissioner of excise, my lord, on the basis of that report accepted the declaration that yes, it is 750. Now that order which was passed by the assistant commissioner has attained finality. No appeal was preferred against the assistant commissioner's order. Now, once the assistant commissioner's order has attained finality, 750, how, my lord, the authorities can again, discarding that order, can say that no, the declaration which was made was wrong, because it was not me, my lord, it was the chartered engineer who operated it and found that the machine is operating only at 750. Now, to say that no, once you have declared at a particular pouches, you cannot change it, then the very purpose of submitting of the monthly declarations and monthly approval will lose all its importance. Because there cannot be any, there will not be any need at all to submit any monthly declarations and monthly approval by the assistant commissioner. Now here only on the basis that no, once you have submitted the declaration, then that is final and that cannot be changed. Now that is contrary to Rule 6.2 and which has been held by the Rajasthan High Court as well as the Commissioner of Appeals Customs. Now Commissioner of Appeals having held that the order was illegal, how the authority again on the same basis of the same facts can initiate the proceedings and raise the demand?
Yes. Yes, where is Mr. KL?
Lordship, Sunil is on next in court number 1.
So you are now aggrieved by the order passed by the commissioner.
I have by the final demand comes up, demand order, my lord, which you will also find at page 280, 275, it starts, my lord. Actually, relevant part is page 385. Is passed by the Honorable Principal Commissioner. I will take a look at the findings.
You're at page 379. I take your lordship to 14.1, my lord.
14.1.
The packing machine so-and-so became operational at the factory at the maximum speed of the said machine as 750 pouches per minute. Between their declaration dated so-and-so and so-and-so, the said notice has declared the maximum packing speed at 1000 pouches per minute. A machine cannot have two maximum speeds. Either it is 750 pouches or 1000 pouches per minute. Operating speed can be fixed by the operator as per his convenience, but the maximum seeking speed, which is the act of the manufacturer or the machine, cannot be changed. Now we will also will see here, as per the supplier, the CPU was changed of the machine. Now we will also see while issuing the purchase order, the said notice has specifically asked for the machine to be used for packing of masala so-and-so at 15,000, 16,000 per minute and 9,000, 900 and 1,000 per minute as per the invoice issued in so-and-so. Because the letter dated so-and-so to the Jurisdictional Assistant Commissioner of Central Excise, intimating of the malfunctioning of the machine, the said notice has been operating the said machine with the declaration maximum speed of the pouches of 1,000 above 751 from so-and-so onwards. The said notice declared the maximum packing speed of 750 per minute in from so-and-so in respect of the said packing machine on so-and-so, and the timing of the change of the maximum speed is conspicuous as the duty structure was changed in the union budget with the issue of the notification dated so-and-so. The rate of duty of the packing machine, packing palm masala falling under so-and-so of the said schedule to the Central Excise Act 1985, manufactured with the aid of such machine, was to be determined on the basis of the maximum packing speed of the machine can be operated for seeking of specified goods which are packed in the pouches. Due to this change of the duty structure, the difference in the duty payable one day and so-and-so comes to so-and-so. Thereafter, my lord, it appears the maximum speed of so-and-so, he's writing this, the my lord, about the statements which have been made. The lordship may skip over. The lordship may come to page 382. From the facts and documentary evidences stated above, I am convinced and hold that the said notice had contravened the provisions of section 6, 7, and 9 of the so-and-so determination rules, and by resorting to the liberal misdeclaration of the maximum packing speed of the machine so-and-so. Now, your lordship may kindly see, my lord. I will show to your lordship, my lord. Page 108.
Yes.
So this was the order passed earlier, my lord, by the Assistant Commissioner. And you'll also will find the operative portion at page 111. Regarding the submission not to ignore the technical trial run of machine by which the maximum packing speed of the machine was determined to be below 751 per minute, I find that the capacity of the machine and corresponding duty liability of determined only on the basis of the maximum packing speed of the machine at which it can be operated in terms of notification number so-and-so dated so-and-so. It is also relevant to mention that such maximum packing speed of the machine as evident from so-and-so above, about 1,048 pouches per minute for the product Rajnigandha Pan Masala at 18 grams and RSP of 50 per pouches. Since there is no change in the RSP of the product proposed to be manufactured with effect from so and so, proposed in Form 1 declaration dated so and so, I do not find any justification to take recourse to the technical trial of the machine and the machine on the opposed to the SSC. Well, the assessing officer discarded the trial run which were done in possession of the chartered engineer of the excise department, who Milord operated the machine and found that what is the capacity of the machine. Now, against this order, Milord, appeal was preferred, which you'll also find at page 113. And 127, you'll also see. Para 9, Milord.
Yes.
Accordingly, on so and so, the trial run of the machine was carried out in presence of the government chartered engineer engaged by the department and departmental authorities. The chartered engineer in report certified that the rotary type single track so and so machine, which had been installed at so and so, shed number so and so, industry unit, is tested for capacity of 18 grams so and so Rajnikanda packing and so onwards, and found 730 plus minus 5 numbers of the pouches machine with regard to 10 grams. We observed and performed that in several times manual and automatic technique, and came to the conclusion that the capacity of the machine is 730 pouches per minute, both 18 grams and 10 grams. This was the finding of the chartered engineer, Milord. Based on the physical trial run and certification of the department engaged chartered engineer, the concerned assistant commissioner had passed the order dated so and so, determining the maximum packing speed of the so and so to be 301 to 750 pouches per minute. The chartered engineer and certificate is an authentic document to verify the speed of the machine, as discussed in para B42 of the minutes of the tariff conference held on so and so. I find that the determination of the machine speed at the subject in June so and so, the actual packing machine speed from so and so as under. I find the consequence of the passing of the order dated so and so, determining the maximum packing speed of machine to be so and so, the assistant commissioner had passed the following orders to determine the maximum speed of sorting machine, and appellant had paid their duties from June 2015 to October 2015 as assessment made by the assistant commissioner. Now, Milord, on the basis of this trial and Milord, for this month, 301 to 715 was accepted. It is also observed that the said orders have not been challenged and no appeal was filed by the department. Now, this, Milord, the orders which were passed by the assistant commissioner were never challenged and they attain finality. I observe that subpara 6 of rule 6 of the so-and-so rules, if the manufacturer wishes to make any subsequent changes in respect of the parameters which has been declared by him and approved by the concerned DC AC of the Central Excise in terms of sub-rule 2, he shall file a fresh declaration to this respect to the concerned DC and AC of the Central Excise, who shall approve such fresh declaration and redetermine the annual capacity of the production following the procedure specified in Rule 2. Sub-rule 6 has mentioned some examples of such changes, but such changes cannot be restricted within the parameters of the examples mentioned in sub-rule 6. It is cleared from the starting words and ending words, etc. Further, as per sub-rule 2 of Rule 6 of the rules, shall, after making of the such inquiry as may be necessary, including physical verification, approve the declaration of the maximum packing speed which the machine so-and-so can be operated. My Lord, it is not so that the declaration, whatever is submitted, is to be approved as it is. The assistant commissioner has to make his inquiry, and after inquiry, my Lord, he has to approve it. Now, in the present case, my Lord, the chartered engineer was deputed by the excise authorities, who determined, my Lord, operated the machine both automatic as well as the, my Lord, manually, and thereafter found the capacity of the machine. in on a plain reading of the provision, I am to consider view that the assistant commissioner determined the maximum speed of the machine subject machine following the above provisions of sub rule 2 of rule 6 of the so-and-so masala and relying based on the certificate issued by chartered engineer. I hold that the order number so-and-so and subsequent orders dated so-and-so in respect of redetermination of the annual capacity of the production passed by the assistant commissioner are in accordance with law and justified. Furthermore, the said orders passed by the assistant commissioner have not been challenged and no appeal was filed by the department. Now we'll also see the conclusion at page 130. Para 13 below.
Yes.
I filed that while passing the impugned order for redetermination of duty for higher quantity, the adjudicating authority failed to apply mine judiciously. The adjudicating authority passed the order simply based on the earlier declaration submitted in May 2015 without going into inquiry and physical verification and totally ignoring the order dated so-and-so, determining the maximum packing speed of the subject machine to be so-and-so pouches per minute and subsequent orders dated so-and-so and so-and-so passed by the assistant commissioner, which were not challenged and no appeal was filed against them. It is not understood that on what basis the adjudicating authority redetermined the duty speed of the higher side. It can also be seen that the maximum speed placed on the machine can be operated was less than 750 per month and so. Now, on the basis of that, the order of redetermination was set aside. Now, after the earlier orders having been set aside, a fresh so-called notice, a proceedings were initiated again, and again the fresh order has been passed.
Against this order, no appeal.
Appeal in fact, no stay. There is no stay.
Yes.
So once below the Commissioner of Appeals has set aside the earlier orders, saying that the order passed by the adjudicating authority determining the maximum speed of the machine on the basis of the report of the chartered engineer was correct, and the subsequent declarations which were filed, which have been accepted by the adjudicating authority, have not been challenged, and thereby the earlier subsequent determination made was set aside. How the authority can again proceed fresh again by issuing so-called notice and by initiating the proceeding again passing the fresh order?
Okay.
That will be below the judicial hierarchy, my lord, if the Commissioner of Appeals orders are disregarded and earlier order is set aside and the fresh orders are passed. Then, my lord, this order will have no meaning.
What is the stand of the respondents here?
Respondents said the same thing, my lord, the first declaration which has been made, that is the declaration. You cannot change it.
What is the provision in the act and the
No provision of the rules, it is there, my lord, that rules. You ask me, see rule 6 there.
Yes. What rules?
6, my lord.
No. What is the name of the rules?
It is rules.
Packing. All right. Rule 6.
Rule 6, my lord. You ask me, see sub rule 3, my lord. A third page bottom, my lord.
Yes.
The annual capacity of the production shall be calculated by application of the appropriate quantity that is deemed to be produced by use of the operating machine as specified in Rule 5 of the number of the packing machines in the factory during the month beginning in which the capacity is to be determined. Thereafter, let me see, the number of operating packing machines during the month shall be equal to the number of packing machines installed in so and so. The machines which have been manufactured does not intend to operate shall be uninstalled and sealed by the so and so. provided that in case it is feasible to remove the packing machines of the factory premises, it shall be uninstalled and sealed by the superintendent excise in the manner it operates. 6, your Lordship, if in case a manufacturer wishes to make any subsequent changes with regard to the parameters which has been declared by him and approved by the Deputy Commissioner of Central Excise or the Assistant Commissioner of Central Excise, as the case may be in terms of Rule 2, such change relating to the addition or removal packing machines in the factory seeking declaration, alterations in the part or section of the approved premises in the number of machines to be used in such part of the machine or commencing manufacture of goods of a new retail prices or discontinuation of the manufacturing of the goods existing retail prices, etc. It shall file a fresh declaration to this effect at least 15 days in advance to the Deputy Commissioner of Central Excise, Assistant Commissioner of Central Excise, as the case may be, who shall approve such fresh declaration and redetermine the annual capacity of the production following the procedure specified in sub-rule 2.
15 days advance of which date? Next month.
My lord. My lord. Now, to your Lordship,
No, where is the monthly statement to be given?
my lord.
Where is this monthly determination required?
I will submit it, Lord. To your Lordship, sub-rule 2, my lord. No, sub-rule 2 of Rule 6.
Rule 6. Yes.
So on receipt of the declaration referred to sub-rule 1, the Deputy Commissioner of Central Excise or the Assistant of Central Excise, as the case may be, shall, after making such inquiry as may be necessary, including physical verification, approve the declaration, determine the pass order concerning the annual capacity of the production of the factory within the 5 working days in accordance with the provisions of these rules. Rule 6, once your Lordship,
Yes.
a manufacturer of the notified goods shall immediately, on coming into force of these rules, and in any case not later than 10 days, declaring from 1, the number of the single machine available in so-and-so, the number of the packing machines, so-and-so, the number of packing machines out of which he intends to operate, the number of multiple tax. You'll also see the different declarations which has to be made. I mentioned, my lord, in the rule sub-rule 2. Whenever the declaration is made, my lord, the Assistant Commissioner has to apply his mind, and after making such inquiry, he has to approve it.
You did not apply for you applied for modification.
Yes, my lord. And on the modification, my lord, what I applied, the Assistant Commissioner appointed the chartered engineer to verify the machine physically, and the chartered engineer and excise authority operated the machine both manually as well as automatic, and thereafter submitted a report to the Assistant Commissioner. And on the basis of that report, he approved my declaration.
Yes.
So once it has been declared, my lord, on the basis of the report of the chartered engineer, my lord, of the excise department, my lord, how the department can again go back and say, my lord, no, that is not acceptable. You'll also see the acceptance order at page 97.
Yes.
You'll also see first paragraph, the 5th line. The SSC wide letter dated so-and-so has requested for allowing to run the packing machine so-and-so, machine number so-and-so, at the actual maximum package speed of for technical alterations. The need for the technical alteration arises due to
defective, ineffective sealing and improper pouch permission and customer complaints received from them. In this regard, the SEC requested for resealing the machine on so-and-so and for the trial run in presence of the technical excise of central excise authority. Thereafter sealing the machine after completion of the machine trial run. In view of the above request, a government registered chartered engineer was engaged while this letter dated so-and-so for determining the actual maximum packing speed after technical alterations. The trial run was carried out on so-and-so in presence of the departmental authorities. The pouches produced during the trial were destroyed and the machine was reinstalled and sealed after under physical supervision of the department of authorities. The SK Datta chartered accountant, chartered engineer in his letter has certified that the rotary so-and-so machine installed in so-and-so for determining the capacity packing so-and-so pouches per minute was sealed as several times, was treated several times by adopting manual as well as automatic techniques. And he has come to the conclusion that the maximum speed of the pouch packing machine is 730 pouches per minute for so-and-so. Therefore, based on the above report of chartered engineer in terms of rule 6 of so-and-so rules, as sometimes I redetermine the annual capacity of the production in respect of so-and-so.
We like. Yes.
So it was not that I have declared and I have done something. I requested the excise authority, my lord, appointed the engineer, and on the basis of that,
Yes.
the order was passed. Now this order was not never challenged. It attains penalty. That's why the excise, my lord, the appeal authority said, my lord, that once these orders have attained penalty, you cannot redetermine it.
Yes.
Mr. Carr, I think that statement I will place before also the relevant judgments and all.
When is he available?
Lordship, any date, Lordship.
Next, have it on 13th? 13th of June?
Okay.
13th of June?
13th.
List on 13th of June.
Other three cases, my lord, on the basis of the first case, penalty of about 30 crores has been imposed on two directors, operating officers and all those.
You're protected.
I'm protected.
Third Dr. Saraf, assisted by Mr. Datta. Counsel for the petitioner, the matter has been heard at some length. For further hearing to continue on 13th, 6, 2024. Since the meetings are completed, it has been heard for further hearing to continue on 13/6.
Deeply obliged, sir.
इसको यहाँ डालिए उनको अंदर डालिए
Please. Lord, I'm seeking for some more time. Please, come. I received the communication, madam.
Yes, Mr.
Respondent number 2 was supposed to file an affidavit in terms of the order dated 18/3/2024, madam.
Mr. P.J. Talukdar, Learned Senior Counsel, requested by MS so-and-so, PR Panto,
For respondent 4.
By Mr. N. Goswami. Appearing for respondent?
4, madam.
No, no, Mr. Talukdar.
Correspondent two.
Correspondent two prays for further right. It is instructed. File necessary affidavit is so advised. His prayer is not approved by Mr. Bachchani, Learned Counsel Commissioner. Mr. Singh appears for
Respondent four,
respondent number 4,
4 and 5.
4 and 5. Mr. Talukdar, you appear for 2 and 3.
Two and three.
MSPR Monto for 1. List again after, how much time do you require?
Months time.
1 month.
1 month. 4 weeks they're asking for one.
All right, 3 weeks matter will be listed after reopening in July on a date to be fixed by the registry.
July.
Registry will fix a date in July.
After vacation.
It's okay.
Apply.
Your Lordship, kindly pass over the matter for the time being.
In this matter, my lord, I am awaiting instruction. Can it be after 3 weeks so that I can make an endeavor to have the instruction now?
But Your Lordship, kindly after timing my seniors in lag in court number 17.
All right, at 2 p.m. Second half.
Fine.
Lordship, if your Lordship kindly pleases to pass over for time being. Lordship pleases to pass over for time being.
Time being.
Yes, Lordship.
Second half.
Oblige, Lordship. My lord, the order dated last 26 to a report was called for from the deputy commissioner regarding the genuineness of my Hatia. That report has come.
No, need some time.
You need some time.
2 weeks.
So that
I may be
that
allowed 2
come.
weeks, my lord. That report is yet to come, my lord. Some date may be fixed. In the meantime, I will obtain the report.
In terms of the earlier order dated 26/4,
Yes.
2024, direction was issued to the Deputy Commissioner Torong to conduct an inquiry into the genuineness of the documents and annexed to the writ petition and Annexure B and file a report by 27/5/2024. Stop. Today, when the matter is called up, and Ms. M. Bormon, Learned Government Advocate, prays for further time.
2 weeks, my lord.
He prays for further 2 weeks' time. In view of the order passed earlier, let the matter be listed after 2 weeks on a date to be fixed by the registry.
Date will finally be fixed.
Mr. Upadhyay appears for the petitioner. After 2 weeks, date will be fixed by the registry. Or you want a fixed date?
After 2 weeks, any day.
19th. 19 June. Based on 19 June.
Obliged.
And Mr. Roy appears for
IGGL, respondent number.
respondent
Five,
number
my lord.
5, assisted by so and so.
And I prefer respondent number 6.
Mr. N. A. Kolita appears for respondent 6.
Yes.
And A. Bhattacharya for respondent 1. List accordingly.
Obliged.
This petition, they have filed a affidavit. Petitioner two will file a reply.
Mr. P.P. Bora, Learned Counsel for the petitioner submits that he'd like to file a rejoinder affidavit, the affidavit filed by the respondents. Mr. P. Nath appears for the petitioner, Ms. M.D. Bora, sorry, for the respondent.
For the respondent number 2.
Respondent 2, M.D. Bora for
1 and 3, as a transport matter.
1 and 3. Matter be listed in July,
Yes, Lordship.
in the month of July after reopening on a date to be fixed by the registry.
Deeply obliged, Lord.
And affidavit has been sent for vetting, Lordship, so we seek 1 week's time, we'll file it in.
My senior is in port number 1 from maybe.
He is praying for 2 weeks' time.
In
2
1
weeks.
week, we'll file it.
And they are paying for time.
We are listing it after a week. After 1 week.
Lordship, date and.
Yes. Mr. I.H. Borthakur, Standing Council Forest, renews his prayer for further time to file reply affidavit. So, since sufficient time has been granted earlier, as a matter of last opportunity, matter stands adjourned for 2 weeks, enabling the Forest Department to file their affidavit. Mr. Your name?
M. Islam.
M. Islam appears for the petitioner and to be listed on 19th
Lordship.
June.
Lordship.
Your Lordship will kindly see order dated 24/4/24. By that, my lord, the health department was pleased to take time to file the.
My lord, we have been newly completed in this matter, my lord. I'm bringing.
Your name appears not newly implemented.
My lord, I'm under instruction of Mr. B. Gogol, my lord. Thank you, my lord.
So if your name is reflected in the last order,
My lord.
why are you saying newly implemented? Yes, what happened to your affidavit?
My lord, 2 weeks time may be granted, my lord.
2 weeks further time.
My lord.
My lord, let them give some more time so that they can list it after vacation.
Mr. A.C. Buraguhail, a senior counsel, assisted by MS S. Nath, appeals for the petitioner. Mr. H. Burua, standing counsel, health, renews his prayer for further time to file affidavit in opposition. Prayer made is not objected to by the counsel for the petitioner. Matter be listed after the reopening date, after the vacation, on a date to be listed in July after vacation on a date to be fixed by the registry.
My lord,
the respondents are expected to file their
my lord,
counter affidavit in the meantime.
interim order.
Passed earlier will continue until further orders.
Highly obliged, my lord.
May I please, your lordship.
Affidavit file.
Philippine, my lord, pollution control board yet to file, my lord. So the main, my lord, respondent.
State respondents are filed.
Not file, my lord.
It's a direction to file it within 2 days prior to the next date of hearing. Who's for the state respondent?
Just to find what? One idiot.
Forest.
No, not forest.
Then?
The revenue, my lordship, respond number 3 already filed, lord.
No, respondent is pollution board.
Respondent fee.
Who is the state respondent? DC and circle officer. DC and circle officer has not filed.
Lordship,
He is the pollution control board member. 2 and 3 pollution control board, 4 is the district commission Dorang. This deputy commission not yet filed, my lord. And question, my one. Nine. Number 38.
Yeah, my lord, Mr. Bhatti is unwell today, so I pray for a week's time, my lord.
Prayer is made on behalf of Mr. O.P. Bhatti, Lawrence, counsel for the petitioner. Until the proxy counsel appearing on behalf of the petitioner submits the matter be posted after 2 weeks. Meanwhile, the state respondents are permitted 2 weeks further time to file their affidavit as directed by the earlier order date is 3/5/2024. Mr. T.J. Monroe, signature
Respond number 6, we have already filed affidavit.
assisted by so-and-so,
Three
appears
Google.
for response. Signature. And the affidavit is already been filed.
Already filed, madam.
List after 2 weeks.
My lord, give you.
39 and 40.
Affidavit দিতে আছে আমার?
Yes. Yes.
May please. My lord, there are two cases. These two cases relates to, my lord, reclassification of land. There is a state legislation, my lord. Assam Agricultural Land Act 2015. And under this act, my lord, the scheme has been laid down. A procedure has been laid down for reclassification. And the deputy commissioner, my lord, is the competent authority who would consider, my lord, the application for reclassification. After, my lord, obtaining the report from the circle officer and other competent authorities. And thereafter, he will place, my lord, the applications and other reports before the district level committee. And pursuant to in principle approval of the district level committee, the reclassification process will come to an end. Now, while this was going on, my lord, suddenly, my lord, petition came from the NHIDCL saying that stop this particular process. And on the basis of such a letter, my lord, the deputy commissioner had virtually cancelled the reclassification process, which had come to an end short of the receipt of the premium. The moment, my lord, we pay the premium, the process, my lord, stands completed. Now, the question is, my lord, whether an extraneous authority to the act can intervene, my lord, in this particular process. The very intervention, my lord, by the NHIDCL and accepting the same by the deputy commissioner, my lord, is absolutely, my lord, not permissible without jurisdiction, and therefore the impugned cancellation, my lord, is liable to be interfered with. Basically, in long and short, my lord, this is the case. And the affidavit filed by, my lord, the
Land belongs to whom?
land belongs to the petitioner.
The petitioner.
My
Been settled in your name.
We are patta holders of that land. We filed application for conversion of, my lord, the land to industrial land. This process was going on. And subsequent to completion of this process, my lord, the acquisition process under the Highways Authorities Act, my lord, came into being. So therefore, the acquisition process is subsequent. And our process under the state legislation, my lord, is prior to that, and which had virtually completed, my lord. And at that stage, my lord, this was interfered with, my lord. My humble submission is, my lord, the NHIDCL, being an extraneous authority in respect of the state legislation, my lord, is without any jurisdiction to interfere thereof. So therefore, the impugned cancellation by the deputy commissioner acting on the advice of, my lord, the NHIDCL is liable to be set aside.
Where is the communication of the NHIDCL?
Yes. That, my lord, communication is at page 79, annexure 8, my lord. This is 2124 to the district commissioner, Karimganj district, status of land for publication and 3 notification. It reads as follows, my lord. As you are aware, NHIDCL is undertaking 4 laning of Badarpur, Toribai section of NHL land acquisition for the same is under process. It has come to notice of this office that commercial diversion change in class of several lands have taken place till date. There is very high probability that landowners might have intentionally applied for change of land classification for obtaining higher compensation. As per ratio laid down by the Honorable Supreme Court in several judgments, such motivated transactions are not to be considered for compensation purpose. The survey in Karimganj district has commenced from 15/9/23 and stakeholder meeting was held on 21/9/23. Therefore, it is kindly requested not to consider any change in classification of land for which application have already been made by the landowners on or after 15/9/23. So basically, my lord, this is the letter. And pursuant to this letter, the Deputy Commissioner, my lord, had passed the impugned communication, cancelling, my lord, the classification process. If your lordship comes to page 80, Annexure 9. In pursuance of the letter number so-and-so, dated 2/1/24, the earlier letter, my lord, from the Deputy General Manager, NHI DCL, the 19 numbers of application for reclassification of land under Nilam Bazar Revenue Circle approved in DLC meeting held on 20/12/23 at 3:30 PM in the conference hall of DC Kamrup, Karimganj is hereby cancelled. Admittedly, my lord, the applications were submitted in the month of December 23 and the 3A notification.
Where is your application?
Yes. The applications, my lord. If your lordship takes the note of the dates, my lord, the applications are 1/12/23, 5/12/23, my lord, and 11/12/23.
Is it enclosed to the petition?
Exactly, my lord, enclosed, my lord. Those are, my lord, from page 52 onwards, my lord. Applications.
So this is the acknowledgement. Where is
My
your
lord.
application?
The application acknowledgement, my lord, here.
No.
Yes.
This is the acknowledgement by the authority
My lord.
that your application has been received. Where is your application?
My lord, it is reflected here, your application for NOC for reclassification for transfer for has been submitted.
How have you submitted the application?
Online, my lord, online. It is on 5/12/23. It's indicated here, my lord. Online. Online application procedure, my lord. This is an online acknowledgement, my lord. And applications, my lord, were admittedly deposited on 1/12/23, 5/12/23, my lord, and 11/12/23. And DLC meeting, my lord, for the purpose of in principle, my lord, approval, had admittedly held, my lord, on 20/12/23.
For what purpose you wanted the conversion?
For the purpose of, my lord, setting up some industry, etc. my lord. And page 49 onwards, my lord, we have annexed certain documents which will go to show, my lord, that it was started. Industrial activities, my lord.
49. 49.
My lord, 49. Same petition, my lord. Page 49, Annex 2, my lord.
Yes.
Then subsequently, what had happened, my lord?
This is already existing or you were?
Existing.
It is existing.
Yes.
On the same land.
My lord, same land.
Before it was converted to commercial.
Okay.
Then?
Thereafter, my lord, what had happened? The DLC meeting was held on 20/12/23. And on that meeting, my lord, the in principle approval as required, my lord, under the Act was granted. And we were asked to, my lord, pay the premium. And in the meantime, my lord, the letter by the NHDSL, my lord, came and the Deputy Commissioner had cancelled the entire process, my lord.
Yes.
And your lordship will see, as required under the Act, the report from the circle officer was obtained and other authorities, including, my lord, the Agriculture, Director of Agriculture, my lord, was also obtained. There was, my lord, concurrence on their part, and subsequent thereto, the entire report along with the applications were placed before the DLC and the in-principle approval was granted. Here the question is, my lord, whether an authority who is extraneous or the deputy commissioner can act upon, my lord, the advice of a extraneous authority and thereby cancel it, my lord. Because this is a process, my lord, and the
There is no, there is statutory right that you can establish.
my lord, here your lordship will kindly see, there is a statutory duty enjoined on the deputy commissioner. He has to, my lord, exercise, he has to discharge his duty in the manner, my lord, which is provided under the Act.
What is the stand of the DC?
DC, my lord, yes. If your lordship comes to the affidavit of the DC, deputy commissioner, my lord, it starts from page 84, my lord. Respondent 3 and respondent 5. Deputy commissioner and additional district commissioner. Now, if your lordship comes to, my lord, page 92, this is the letter issued by the deputy commissioner saying that all the formalities were completed. Why did you issue that letter? Page 92, my lord. This is the letter of the deputy commissioner, 11th June 2024. Subject, status of land for publication in 3 notification. Reference, your earlier letter dated 2/1/24, the impugned letter, my lord. Sir, as mentioned in your reference letter, you have stated that NHI DCL is undertaking 4 laning of Badarpur, Chorabi section so-and-so and acquisition for the same is under process. And you have mentioned not to consider any commercial diversion change in class after 15/9/23. Here some of the facts has to be mentioned in this regard. Land acquisition under National Highway Act 1956 has provisions of 3A is for appointment of Kala, competent authority under land acquisition. 3A is power to acquire the land under 3A through notification under subsection 1 with the brief description of land such as DUG number, class of land, etc. These are followed by steps 3C, 3D, 3E, F, G, etc. Further, section 26 of the RFCT LAR Act stipulates the date of determination of market value shall be the date on which the notification has been issued under subsection 11 corresponding to section 3A of the NH Act. So in this case, the class and value is freezed after 3A notification only. The basic market value of land is to be determined as on the date of preliminary notification under section 3A of the NH Act 1956. Further, you have also put forward in your reference letter to fix the date on 15/9/23, whereas no 3A notification is published till date. It is to be mentioned, DC office has received the reclassification proposal in month of December, which were considered in SLA DC dated 20/12/23 month. And the 3A notification has admittedly come about on 18/1/23. Pursuant to, my lord, the in principle approval by the district level committee. This is, my lord, the version of the deputy commissioner, my lord. 4, it is important to mention that for any kind of reclassification of land, more than 1 bighas, the party concerned have to pay premium of 10% of existing zonal value. Again, for reclassification of land, reports from agriculture, forest industry, soil conservation, water resource, VLM SSC reports are required where the land should be lying as follow for several years as per Act. As after receipt of all reports from concerned departments, my lord. Reclassification were proposed out as per rule after observing all procedure and necessary formalities, that is to prior to 3A. So, my lord, my submission is Deputy Commissioner letter makes it abundantly clear the entire procedure as contemplated under the Act was duly followed, my lord.
What is the para 5 of the letter?
Para 5. Thus, depending on the above mentioned facts, I would like to request you to kindly clarify how the 15/9/23, this is the cutoff date fixed by NHI DCL, is fixed with respect to NH Act 1956, RFTC LAR Act 2013, and recent Honorable Supreme Court judgment where 3A is carried out till date.
No 3A.
No 3A is carried out till date.
What is 3A? 3A
3A, my lord, in
notification.
respect of the notification under
3A
the,
notification.
yes, my lord, 3A notification on the Highways Act 1956. my lord. B, if the duly proposed reclassification done in SLDC on 20th December before publication of 3A is valid or not. Then, my lord, next page, further, district administration has already instructed the circle officer not to entertain any change of nature of land once 3A is done. So the prohibition, my lord, will come into play after the publication of 3A notification under the Act. The letter makes it very clear. And the entire, my lord, exercise was done, my lord, before the publication of 3A, admitted on the materials on record. Now, what the, my lord, NHIDCL says, my lord, in response to the letter by the Deputy Commissioner, it starts from page, my lord, 95. Page 96, my lord, NHIDCL says, in case district administration finds such applications for change in class of land genuinely based on records as per the methodology adopted in the state of Assam for reclassification of land, this office has no objection to such genuine cases. In case the survey members who have been classified in SLADC on 2012-23 are found to be genuine based on parameters set by the administration, they can be considered valid. This is, my lord, the affidavit. And if your lordship comes to the prohibition, my lord, I have annexed, my lord, at page 81, the circular of the, my lord, central government comprehensive guidelines. The operative part is at page 82, 10.3. This is, my lord, the prohibition. 10.3, my lord, your lordship has got it. Page 82. Certain undesirable practices have come to notice of the central government. These include change in the nature of land or adoption of incorrect classification of land for determination of market value of land. It may be noted that the nature of land has to be taken as recorded in the revenue record on the day of publication of 3A notification. For instance, if some landowner interested person has raised a factory building or a commercial building upon the land under acquisition without obtaining the change in the land of use for the competent authority prescribed by the state government, he she cannot take the benefit of treatment of such land or industrial or commercial. Therefore, due diligence has to be exercised by the Kala while determining the land use, nature of land, and working out the market value of the land. So therefore, my lord, if the process starts before the issuance of 3A notification, the bar will not apply. And interestingly, my lord, in the affidavit filed by the NHIDCL, if your lordship comes to page, my lord, 107, the 3A notification declares, my lord, the land belonging to the petitioners and not as non-agricultural industrial land. Page 107, I'll indicate the dark numbers, my lord, 284.
So if it is already classified as industrial,
yes,
then no further reclassification.
Subsequently, without affording opportunity to us, in the 3D notification, they have again reversed it, my lord. This could not have been done. The applications are pending before the, my lord, Deputy Commissioner.
Where is that 107?
107.
Where?
Page, my lord, sorry, my lord, the
Serial number?
Serial number 230, the dark is 284. 232, dark 286, your lordship will see the fourth column, non-agriculture, non-agriculture. Then 293 dark number, non-agriculture. 294, non-agriculture. 295, 296, 424, 426, 427, 440, my lord. Next page, 442. All, my lord, are indicated to be non-agricultural industrial land. And subsequently, when the 3D, my lord, was issued, those are shown to be, my lord, agricultural land. And your lordship is aware.
Yes.
3A relates to official notification of official gazette. Now, there is in between 3C, my lord. hearing of objections. Without inviting, my lord, any objections from us, the 3D notification reverses, my lord, the status of the land, which is absolutely, my lord, illegal. 3C makes it clear, hearing of
Where is
objection.
the 3C notification? The 3A notification?
3A notification I have pointed out, my lord, that.
This is 108.
Yeah, 107, 108.
107.
Yes.
Then there is the 3C notification.
Yes, my lord. 3D notification.
Where is it?
Page, my lord, 121. Twenty-four, 26. Page 122, your lordship will see, Dag number 284 is shown as, my lord, agriculture. Two 293, 294, 295, 296 converted to agriculture, my lord. Without, my lord, complying with 3C, this could not have been done.
Yes.
My lord, the entire issue raised on this case is whether the cancellation by the deputy commissioner on the behest of NHI DCL, my lord, can sustain in law. In this context, my lord, I'll place the Purtapur's case, my lord. The Ken Commissioner's case, your lordship is aware. The Ken Commissioner acted at the behest of the Chief Minister, my lord. Changed the earlier plan. Honorable Supreme Court says that the Ken Commissioner is the authority under the statute, not the Honorable Chief Minister. Therefore, it was interfered with, my lord. Same case, my lord. The Deputy Commissioner, my lord, is the authority who has to finalize the reclassification process. Acting at the behest of the NHI DCL, my lord, the entire process got to be vitiated, my lord. Because it's an extraneous authority in terms of the act. If your lordship takes up the decision, my lord.
Use for the DC. Let's hear the DC. We'll just come back to you.
My lord, correct.
Yes. You're for the DC.
Lordship.
So, you have changed the classification or you have gone back, you have not accepted the findings of the STLAC.
Lordship, in our affidavit, Lordship, you have mentioned, everything is stated, Lord. Why it has been done.
Why it has been done?
Lordship, my lord, kindly see. So, page 87, 89. The Lordship.
Yes.
Lordship. Married, Lord. Order, a letter has been sent to
NSIDCL, white letter number so and so, for the notification related to the aforesaid matter, and a reminder has also been issued to office white letter number so and so dated 21/1/24. In this letter, the clarifications had been sought for on 2 points. Firstly, how the 15/9/23 is fixed in respect of NS Act 1956, RECTLR Act 213, and a recent Supreme Court judgment. And secondly, if the duly proposed reclassification proposal done in the DLC on 2012-23 before publications of 3A is valid or not. In pursuant to the letter dated so and so, has submitted a detailed report white letter number so and so dated 23/1/24, in which it is mentioned that when the survey started at any particular location, the land to be acquired become known to the local populations. It is likely that the certain landowners started buying or selling their land and started land conversation before the actual 3A gazette notification is published in order to.
Why do you, 1 minute, why do you want this conversion? Why do you want this reclassification? It's your land.
Yes.
Pata land.
For the purpose of industry.
It's already
Agricultural
there.
land.
That's what he said.
No,
The brick kiln is already established. Continuing.
we have just started, my lord, but to, for a full-fledged, my lord, industrial activity, reclassification is necessary, my lord.
Where is the report of the?
Yes, yes. I'll come to the reports, my lord.
SDLSE.
Yes.
Is it? SDLSE report is based on?
Yes, I'll come to the reports, my lord. The report starts, my lord, from page 63, Annexure 4. This is a report of Director of Agriculture, Assistant Director of Agriculture, my lord.
63.
63. Report starts from here. He writes to the circle officer. On observation, the last part, my lord, on observation, it is seen that applicant along with his partner have demarcated the area for the purpose of installation of one chimney brick industry. As an industry of such type will create economy for his own along with numbers of employees. I have no objection in reclassifying the plot of industrial class, and remaining part rests with the decision of the revenue authorities.
No, for industrial officer, agricultural officer will give a report with regard to whether this land can be converted or
My
not.
lordship,
Where is that finding?
that is not there.
He is merely saying what the applicant has said.
My lord, in fact, the DLC meeting, if your lordship comes to page 74, this was, my lord, rescheduled on 2012-23, and subsequently at page 75, Annexure 3, this is, my lord, the meeting was held. And the members were present, chairman being the deputy commissioner.
Where is the proposal of the circle officer?
This is not part of the record, but your lordship will see page 76 down below. The circle officer Nilam Bazar has proposed the reclassification of aforesaid land on the basis of the zonal evaluation proposed to the government for approval by this office letter number so and so.
Where is the proposal must have had endorsement of the DC?
My lord.
Mr. Hendik?
Lordship.
Any proposal which is to be placed before SDLSE?
Lordship, my lord, that is, my lord,
must be approved by the DC.
that is true, lordship. Whether it is done for the prior to the, my lord, that the DLC meeting, my lord, it is, my lord, not mentioned in the affidavit. Not there at everything.
My lord, this is apparent from the impugn order itself. The entire classification process, my lord, it has been approved. It appears from the, my lord, impugn order at page 80. Now, my lord, that my lord.
If the DC had any material to doubt the authenticity of your request, whether the DC can go back and make inquiry is one aspect. And whether such a thing has been done. If not done, then whether at the behest of NHIDCL such an order can be passed.
Yes.
That's the only.
That is the question, my lord, yes. And apparently, from the impugn order, it
Because
appears.
DC has to apply the mind and say that this is not correct or these clarifications are not there.
Correct.
Why is the DC changing the opinion? DC is the authority of the in the revenue department so far as that particular area is concerned. And the circle officer's proposal perhaps is required to be endorsed by the DC. I think that is the procedure.
Lordship.
That
My lord, this statute,
you find out what is the what enquiries or if anything is there in the records. Otherwise, this order will go.
Lordship done some time, Lordship then.
It is admitted prior to PA.
Lordship, that is true.
So there is a procedure for change of classification. If the procedure has been followed, the approval have been made, that what remains?
Whether the procedure has been followed as per law or not, my lord, it is not clear in the affidavit.
my lord, that is not
what
the issue,
DC
my
is
lord.
supposed to answer.
Lord.
The
That's why-
affidavit doesn't say anything. It
Lordship,
put in
that is-
those letters.
No.
You file an additional affidavit
True.
immediately.
Lord.
Mr. Talukar,
Ma'am.
let us
Correct,
examine the matter and find out why the DC has done the
My lord, if your lordship sees the impugn order, it's absolutely clear. There is no other reasoning except, my lord, the reference of the letter of the NHIDCL.
Or
Had
you-
the DC say,
You go for the records and examine. Your affidavit will take 6 months to come.
No, Lord. I will try my best, my lord, within a short time. My lord. Even then, my lord,
Trying your best indicates that you will not come. We want a positive
record.
vision from you that either you produce the records or you file it on the basis of the records after due examination and affidavit.
Because, my lord, I will produce the record.
Then we continue the hearing next week, produce the record. Go to court.
Otherwise, my lord, that by way of additional affidavit, I want to bring this, my lord, that proposal, my lord, what procedure they have followed during this, my lord, that
No. You can bring it, but the question is how much time?
only 2 weeks time, man. That's because on 4th, my lord, that
Huh?
the counting is going on, my lord, will be, my lord, start on the 4th. But that's why, my lord, they are busy, they will be busy in the, my lord, that counting.
Let us have it on 18th.
Well.
June. 18th of June. You get your records or you file your affidavit to the effect as to what procedure was followed by the DC before cancelling the order. Where is the impugned order?
impugn order, your lordship will find at page, my lord,
Page 80.
80, my lord. Order dated 8th of January 24, my lord.
80.
80. Annexure 9, 80.
Mr. S.K. Talukar, letter. Hearing of the petitioner. So heard Mr. A. Hendik, counsel appearing for the respondents number.
I'm for the. I'm 3, 5, and 6.
1, 3, 5, and 6.
I'm for the NHA district.
Mr. D. Gogoi for.
That's for 2.
2. Petitioner is agreed by the impugned order dated 8th of January 2024, whereby the applications for reclassification of the land under Nilam Bozar Revenue Circle filed by the petitioners, which was approved in the DLC meeting held on 20/12/2023, has been cancelled by the DC Karimganj. Stop. The learned counsel to the petitioner submits that this cancellation is on the basis of a letter issued by the NHIDCL advising the Deputy Commissioner not to change the proposed classification of the land concerned, as the said land would be required for the purposes of construction of national highway in connection with, what is that, for what purpose you want?
Industrial purpose from agricultural to non-agricultural.
National highway? National highway. Which part of the national highway, for what? Construction of what?
alignment to Churaibari or
Bodorpur,
Bodoipur Churaibari section.
Where is your letter? Where is the letter?
That is at, my lord, reflected at 79, 4-laning Badarpur Churaibari section or NH 08. My lord, 79,
Or-
first line, my lord.
For widening or construction of 4-laning of Badarpur Churaibari section of the NH 08 and land acquisition for the same purpose is unfinished. Stop. Although an affidavit has been filed on behalf of the deceased, the same does not throw any light on the procedure adopted by the DC prior to issuing the impugned order, cancelling the proposed reclassification. Stop. Accordingly, the learned government advocate is permitted 2 weeks' time. Placed before the record, placed before the court, the relevant records or end of legal, file any affidavit as to why the DC proceeded to cancel the applications for reclassification of the land which was approved by the DLC. Please, this matter on 18th.
My lord, can it be little shorter, my lord? 11th, my lord.
on 11, I have some problem.
Then 13, my lord.
Okay, on portal counting will be started. So they will busy in the one of
Hari Pishor 14, 13 তারিখ। Hari Pishor 13 তারিখ। 13th, my
Let it be 18 lot.
lord.
It will be.
Okay. 11, my lord, 11.
Let it be on 18th. Let us see. 18th.
So this is a covered case. Me and the petitioners councils have agreed that this can be disposed of with similar directions.
Get ordered.
Okay, para 8 is the operative part.
Facts are almost similar.
Okay. Hard learned counsel for the parties disposed of. This is the order. Yes.
Well, if I may invite my lord's attention, at number 43,
This is adjourned.
it was not consented to. Surprisingly, we could find it from there. We checked it up when they mentioned the online thing. Someone had mentioned albeit without any consent, my lord. I'm surprised these things are happening. We have an interim order now. Some gentleman had mentioned. A young boy I couldn't recognize, my lord. And my friends on the other side have asked them, no consent was given by any party whatsoever.
43 was mentioned by
Yes, a young boy had mentioned the matter. We checked up. No need. And he said with all authority that with the consent.
See, we are
I
making it convenient for the bar to make a mention. Otherwise, there is a process for circulation of adjournments.
I understand.
So we'll stick to that.
Only the interim order is there. Next day we'll take it
We
up.
don't know what date has been passed. Immediately look. If posted it after a week only.
The interim
Some
order-
interim order is there. Item 43. Interim order passed earlier, will continue.
Obliged.
We tend to be
I
rely
understand.
on the submissions of.
Yeah, absolutely, my lord, absolutely. We're taken by surprise, my lord, when we saw that the number was indicated. Obliged, lordship. Continue.
How can Mr. Bonik be taken by surprise?
How was, my lord?
44.
Yes.
44, Lordship, receive instruction, my lord, I am going to file an affidavit.
Yes. Mr.
Yeah.
A. Hendick, learned government advocate, submits that instructions have been received. You'd like to file an affidavit. He prays for 3 weeks' time. Mr. A. Ali, learned counsel, appearing for the petitioner, does not object. Matter be listed in the month of July. After reopening on a date to be fixed by the registry, the government advocate will endeavor to file the affidavit as prayed for in the meantime.
Interim is there.
In fact, I was,
Time being,
for the time being,
No. I think you prayed for some time.
no, in the next case, 32, item 32, my.
what has happened in this case, my lord? The petitioner, my lord, the mother of the petitioner, my lord, she was married to an Abdul Mutlib. And my lord, prior to the birth of the petitioner, my lord, the husband deserted the mother. And the, my lord, the child, my lord, was brought up in the society of the mother. Now, we applied for, since the mother belongs to a, my lord, Kachari committee, right, which is a scheduled tribe committee, my lord. We applied for a caste certificate. Lord, on 2 earlier occasions, my lord, I'll just take you to the orders. Joshua will kindly come to page 26.
What has happened to the contempt? Contempt file.
Contempt was not filed, my lord. In fact, there were read petitions filed, my lord, on earlier occasions, on 2 occasions. Your lordship will find the order at page 26, annexure 4. Was to examine, my lord, paragraph last, without expressing any opinion on the merit of the case of the petition, the petition is disposed of, providing that the respondents may examine as to whether the pending is entitled to grant of SC certificate or not. Depending upon the said examination, further course of action may be taken. Whatever may be the outcome of the said exercise, the same may be communicated to the petitioner. My lord, thereafter, we provided a copy to the on next page, my lord. But they refused to, my lord, because the district tribal Sangha was not made a party in the earlier case. Now, my lord, what has happened, my lord? Thereafter, we again approached this honorable court, which will also find at page 32.
Yes.
Here again, my lord. Just reading up on the 3rd paragraph. The petitioner had earlier considered the WPC number so and so, making a similar prayer for a direction to the respondent authorities, a concert to take steps for issuing certificate, scheduled tribe certificate. The said petition was disposed of on 1960 with a direction to the respondents to examine as to whether the petition is entitled to the ST certificate or not, and depending upon the said examination to take further course of action. In the said WPC number, or the All Assam Tribal Sangha was not implemented as a party respondent. Accordingly, the petitioner as well as state Lana State Council, it is the Assam Tribal Sangha who is competent to issue a scheduled tribe certificate, which must necessarily be countersigned by the Deputy Commissioner of the district concerned. In view of the above, the petition is permitted to make an application before the respondent number 4, All Assam Tribal Sangha, for the purpose of grant of SC certificate. On such application being made, the said respondent number 4 shall consider and examine the matter and so ascertain whether the petition is at all entitled to the grant of ST certificate. In the event of the respondent number 4 is satisfied that the petitioner is entitled to the same, necessary action shall be undertaken for issuance of the ST certificate to the petitioner as expeditious as possible. The process of the completing the exercise at the end of the respondent number 4 shall be done within a period of 4 weeks from the date of receipt of the application of the petition.
Now, what do you want?
Now, nothing happened, my lord. That was there, my lord, but that is the problem, my lord. In the prayer part, my lord. It was the ought to have filed, but it was not filed. The only thing, my lord, there is a
In the meantime, one judgment has come in PIL 30/2019 that Anusuchit Jati Parishad is no longer, they are entitlement for giving the certificate, my lord. In parlance of the judgment, Madhuri Patil, my lord, it is the district commissioner as well as the subdivisional officer. Lordship may dispose of this direction if they are filing a fresh application addressing to DC, my lord, in terms of this PIL order, my lord. Paragraph 8 and 9.
They'll already ordered earlier.
No, they in para, currently produce para 8 of the judgment, madam, 8 and 9.
The notification, is at page, paragraph 3, which was under challenge in the PIL. Paragraph 3, my lord. The PL petition is instituted by the Karabi Kolabari Educated Employed Youth Society and another asserting the notification dated 22/6/2009 of the Secretary of the Government of Assam in the WPT and BC department, by which it was provided that the Governor of Assam is pleased to authorize the President, Vice President of the All Assam Tribal Sangha and the District Unit of Assam Tribal Sangha to identify the status of scheduled tribes communities and issue certificates to the scheduled tribes plain, scheduled tribes hills in Assam within the jurisdiction of the respective districts and subdivision so and so till finalization of the amendment of so and so. The petitioner also assessed the communication dated 5/6/2018 from the Commissioner and Secretary to the Government of Assam in the WPT so and so made to the Deputy Commissioner and Subdivisional Officers Civil in the state of Assam as regards the issuing scheduled tribe plain certificates of the Sorone Kochari community as so and so. Now this notification is withdrawn, which your lordship will find in paragraph 4. Last 3 lines, it is stated that by Mrs. Binita Pego, the Secretary of the Government of Assam in the tribal so and so, that the said notification had in the meantime been withdrawn and it is not having any force. Now, paragraph 6, my lord, the purport of the said provision of the Supreme Court in paragraph 13 of the judgment rendered in Kumari Madhuri Saprat would be that the application for grant of social status certificate are to be made either to the Deputy Commissioner or the Deputy Collector or the Revenue Divisional Officer. Now, paragraph 8. Considering the aforesaid clarification given by the WPT and BC department, which is subsequently renamed as Tribal Affairs P department, we are of the view that the said process, if adopted, would not be contrary.
Order requires the
Lordship. Now, only thing is, they say now it is the Deputy Commissioner.
this order at page 40.
Lordship.
Your interpretation.
Lordship.
The order was passed. Madhuri Party.
Yes.
Direction ought not to have been prayed for in the first.
But at that point of time, my lord, because my lord, the tribal sangha is otherwise authorized to issue. Now, my lord, paragraph 8 takes care of it. My lord. If your lordship sees true, my lord, but paragraph 8 of the PIL, my lord, it says that, my lord, the preliminary inquiry has to be done by the sangha, my lord. If your lordship kindly comes to paragraph 8 of the PIL, my lord.
Is there any notification as of date after Madhuri Party?
That I have to take instruction. I have not updated.
Madhuri Patil was back in 95, my lord. Now, lordship, I was relying on, my lord, this judgment of 2012 3 SSC, my lord.
Ramesh Bhai.
Ramesh Bhai, my lord. If lordship will kindly see, because here is a case, my lord, I have not even seen my father. I was brought in the society of the mother, my lord. That is my case. And if your lordship kindly comes to paragraph 36 of the, it is marked, my lord. Paragraph 22, in fact, it's just 3 lines, my lord. Page 7 of the judgment, my lord. It is thus clear that it is wrong and incorrect to read Bhaltama so and so as laying down the rule that an intercaste marriage or a marriage between a tribal and a non-tribal, the child must always be deemed to take her caste from the father, regardless of the attending facts and circumstances of the case. Now, this is, my lord, paragraph 36 again, my lord. That has been cleared. Internal page 9. It is thus clear that to us that taking it to the logical next step, and to hold that the offspring of such a marriage would in all cases get his her caste from her father is bound to give rise to serious problems. That take for instance,
Okay, but who was ordered, already there in your paper.
so there is true, my lord, but no action has been taken. My lord. Now the problem is
So action can be taken.
the only thing, my lord, now since because of the PIL, my lord, can it be, my lord, like this, my lord, we file a fresh representation. Let the deputy commissioner, if required by the, my lord, they can make an inquiry in terms of the paragraph 8 of the PIL, my lord. Lots of things have not been taken into account. In Madhuri Patil's case was, my lord, the guidelines were framed there. But there are circumstances beyond Madhuri Patil, my lord, which was taken care by Ramesh Bhai.
Either way, judgment is well prior.
Yes.
What happens?
Is there? In fact, because at that point of time, this notification was in force.
Cannot interfere.
No, that is true. That is true. Well, that is why, my lord, let me, I may be allowed to file a fresh representation, my lord. That can be taken care of.
You have already directed by the.
Well, that was, yes, my lord.
By this one.
But
which you have done.
yes, my lord. No action has been taken, my lord. That is why I have come, my lord. Yes, in fact, my lord, contempt petition ought to have been filed that point of time. That was not. Since I am again before this court, my lord.
Yes.
My,
You're
ma-
for who?
I am for the tribal company. In fact, my lord, in the earlier petition,
You're for
respondent 3 and 4, my lord.
Sorry.
All Assam tribal Sangham. Yes, my lord, since the year 2018, my lord, in fact, there is an order of this court not to issue a caste certificate. That petition was tagged with the PIL, my lord. Ultimately, that notification that the government has withdrawn, my lord. Now only the DC is the authority to issue the caste. Earlier also we identified and countersigned by the DC, my lord. No, tribal Sangha was not at any point of time the appropriate authority to issue the certificate. They identified and it was signed by the DC.
Only thing, if your lordship kindly comes to paragraph 8 of the, my lord, PIL, my lord, I'll just for a moment. The applications are pending before the All Assam Tribal Sangha. So, my lord, let them make a preliminary inquiry, my lord, and forward it to the deputy commissioner. That will also suffice, my lord.
No. If it is entrusted by the DC, then only then we can make an inquiry.
In fact, that will take care of the early order also. No.
Role of the earlier.
No, my lord.
No.
To my knowledge, no, for verification, I have to ask with the authority. My lord.
Through my instruction only verification part they are doing if it is instructed by the DC. I will.
What already undertaken. Where that is power verify.
No, my lord, the reservation of SC/ST, there is a provision in the Act, my lord. That empowers the tribal Sangha to identify the caste status. Yes, my lord.
That is, my lord, in the.
That is the Assam SC/ST reservation of vacancy service rules, my lord. 1983. No, my lord, that reference of the rules, my lord.
Notification of the power they are authorized for.
Then it will not.
There are two orders.
True, my lord, but the only thing, my lord, we acted upon it. If your lordship, that is why, my lord, I was referring to paragraph 8 of the PI.
You acted upon it in the meantime, there is a change, but question is what happened? The orders by the court.
True, my lord. Now, that is why, my lord, lordship will kindly, that is why referring to paragraph 8, my lord. Now, here, my lord, the tribal song is empowered to take a preliminary inquiry, my lord. Let them do it, my lord, because, my lord, there are orders of this court. If I am otherwise entitled, my lord, let it be forwarded to the deputy commissioner.
Was from the provisions where tribal council is power.
Wait a minute.
Under the rules.
Yes, my lord.
Which rule?
Rule 3(1)B, my lord.
My lord.
Rule 3(1)B.
Yeah. What does the PIL say?
My lord, PI says that in view of the observation in Madhuri Patel's case, my lord, only the deputy commissioner and all Assam tribal Assam, they can identify the caste status and submit it.
Paragraph 8, my lord.
And what happens to the rule?
Lordship?
Has the rule been amended?
No.
No.
In the PIL, that rule was also selling.
Huh?
In the PIL, when the rule was also selling.
Has it been interpreted?
No, my lord.
Paragraph 8 says, my lord, considering the aforesaid clarification given by the WPT and BC department, which is subsequently renamed by so and so, we are of the view that the said process, if adopted, would not be contrary to any provisions of any other law. If the exercise is limited to the extent of making a preliminary inquiry as to which person would belong to the tribal communities for being entitled to a certificate of their status. But at the same time, we will also provide that the contents of the preliminary
Examination.
Yes, yes, my lord, that is what.
This kind of nursery references will have some ramification.
That is true. That I understand, my lord. But it says, my lord,
Please get your instructions for notification as it should.
After this.
Enforcement, the PIL order,
Mine.
any other order. Because once the rule is there, then it is interpreted. I think we will have to be even. You have not filed any counter affidavit.
No.
my lord.
File a counter affidavit. the principle that their cases
Right.
are likely to be considered, perhaps not under this of Urban High Court implemented.
Yes.
The question is who is going to verify that?
Right.
Who is going to issue that certificate?
Yes, thank you.
Is the petitioner certificate, right? Petitioner is seeking a certificate.
PC is taking a certificate.
For scheduled tribe. Father is the general caste.
Yes, my lord. Abdul Mutli, my lord.
Marriage. Real. Not narrative. Yes. Yeah. Upon Right. Right.
My lord, my lord, I am appearing for respondent number one, my lord. Yes,
Some. That's right. That I don't know. That's it. But right. That right. Mitigate. Pursuit. Of the time by which right. Right. No. What's up? Right.
my lord, I am appearing for respondent number one. Now it is tribal affairs plains, my lord. They are the nodal department for this, my lord. My lord, I will bring on record now that procedure has changed. Now it is online. They have to apply to a portal, Bhumiputra, my lord. And from there only the verification will be done. And accordingly, the certificate will be issued. I will bring it on record, my lord.
Now it
My lord will reflect my name in the progress.
19. No. Let's see what.
My lord.
Well, actually, but date may be fixed for them.
Instruction is awaited, my lord. I praise that 3 weeks time may be granted.
As they. As they.
As they.
Problem.
My
My lord, matter relates to the petitioner is, my lord, praying for a demarcation of his particular plot of land. My lord, under the Assam Public Services Premises Act of 2012. And my lord, the office memorandum governing the conditions. My lord. Now, my lord, we are approaching the circle officer who is the designated authority under the office memorandum. But the circle officer, my lord, is not completing the task. My lord, he has the power either to allow or even reject our prayer for demarcation also. My lord. So, my lord, basing on our application, my lord, he can take up, my lord, and my lord can dispose of by directing within a time limit that he will take a decision on our application, my lord.
In this matter, my lord, I'd like to submit on the verbal instruction under the RTPS Act, my lord. This land is a Azmali Patta land, my lord. So other co-pattadars are also there, my lord. So it requires a hearing on issuing of notice, my lord.
That can
So-
be hearing by circle officer.
Yes, my lord. That is why I am praying 1 month time, my lord. In the meantime, petitioner may file a press application, my lord.
We have
So
already
that-
filed, my lord.
So that he can issue notice to the other co-pattadars also and accordingly do the needful, my lord. I will have the updated instruction after one.
Has the order been passed on the representative?
Not yet, but on last occasion, my lord, that representation reflected without any boundary to that extent, my lord. So Honorable Court has asked petitioner to bring the sale deed in record. Probably if it is they, if including that sale deed, if they file a fresh representation, my lord, and I get 4 weeks time to have the instruction, then lordship.
If you were submitting that, they file the application along with the sale deed.
No, my lord, in particularly in my lord petition, that schedule portion is, I did not find it. That is one of the problem, my lord, for entertaining that petition, my lord. So I pray to your lordship, my lord, if they file along with the sale deed, they,
That is what I am saying.
my lord.
That if we direct them to file, then we close the petition.
My lord.
Or if you want some
No,
time for instruction.
one thing is there, my lord, there that they have to give the hearing to other co-pattadars also.
Right, but it is
If
only
time
upon-
frame may be, lordship
it
may,
is only upon entertaining the.
yes, my lord. So in that case, my lord, they need some longer period of time. If co-pattadars are there, they have to entertain, and if any dispute regarding to that, they have
His
to look into all
grievances
this.
that his application has not been acted upon.
My lord.
That's the grievance.
My lord.
So let it be, let the circle officer hear the matter.
Lord,
Unless you say that you like, you want some time to complete your instructions here.
No, my lord, I have also tried to have instruction from them, my lord, regarding disposal of his representation. And what I have been instructed, my lord, as it is the other co-pattadars are also there, so they need also a kind of hearing, my lord, after issuance of notice, my lord. So it took some time. So let it be pending for after, for after
So
the
you
4
are
weeks.
saying that the matter is.
So that, yes, my lord. For that case, my lord, if I pray, my lord, petitioner may be allowed to file a fresh representation along with the sale deed, my lord.
What kind of a prayer?
With that demand, sale deed, sale deed is,
If the process is on, then why does it?
no, that process is yet not on, my lord. That is their difficulty because they have to issue the notice to the co-pattadars, my
So
lord.
let them issue it, we are closing it. Let them issue on the, whatever documents they require, they will.
My lord, they can ask for documents, anything is required, we will supply, my lord.
That moment of. they have
वो
like
ऐसा
check
कर कौन है? मगर दूसरे ने भाई को कही, वो भी कही।
Copies bill का ये तो बता दो कर दिया ना।
Take that. They, right, take that. I that land shall be approached by the private Yes. It is respect the higher. Considering the boundaries. Right. Right.
Well, it's correct.
This correct.
Right.
49. Any, it's a true.
My lord, notice was issued on, my lord, 18/1/2023, my lord. Right.
It's not that. It- terms of the direction.
Right.
Like that.
We have
In terms of the left that still be respect. Of that, I think the where is the description of the land? Say,
my lord, we have translated it very difficult, my lord. At page 35, it is
no, you
the
show me from
original, my lord, yes. Topsil, my lord, is at page 40, my lord. Kamrup Jilar, Guwahati Mouzar, not Guwahati, Beltola Mouzar, Hatigaon, 370 নং ডাগৰ 3 কথা 5 পেচা My lord, my lord, this is clear, my lord. Zaman,
boundary.
my, please describe, my lord, north, my, Ahmed Syed Ali, South 16-foot width road,
By
road, my lord, east by Ayub and Raman Kumar,
you
my lord, and west is Siddiq Hussain Chaudhary.
by
Right.
and as per it
Is reflected in this.
as scope under the
Yes, he is
Madam, namaste, madam.
there are scope under the
Requirement to
deciding on the claim made by the
Lord, we have filed another one pursuant to Honorable Court's order on 8/2/2023 also. my lord. 8/2/2023. One.
hearing. Date.
One. 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 Obliged, highly obliged.
Item 45.
May it please your lordship. My lord, the writ petitioner does not want to, my lord, press the writ petition. As because, my lord, dispute between the parties, my lord, was, my lord, due to non-ability of MD of Jorhat Agro, managing director. That is in the affidavit of respondent.
Don't want to press it.
Because of this, my lord, they are looking into the grievance for a time being, my lord.
Currently examining.
Currently examined by the Jorhat Agro Private Limited, respondent for society. Four.
Three Bora Road.
Right.
Respondent number 3 Road.
So respondent 1 and 2.
S. Hussain, your worship, for respondent number 4. S. Hussain. Hussain.
Hussain.
My lord, lord, liberty may be given to approach again if the grievance is not looked into. May I indicate one thing? As per the resolution taken on 10/5/24 meeting, that is the resolution taken. Liberty may. Obliged.
Obliged. What we take? 46, lordship, I need some time, lord.
It's a matter of my lord, regarding my lord.
We have served the copies of the affidavit.
Be clean, my lord. That's urgency there, my lord, because the agricultural land, they going establish a be clean, my lord. And that this litigation is kind of started since 2012, my lord. And there is an order from this honorable court, where division is order that before taking before passing any decision, to take a report from the, my lord, DFO, district health officer, and the pollution control board. They have to, without, my lord, calling for the report, my lord, on the basis of the order passed in 2008, my lord, the DC has passed this order, impugn order, and when NOC has been, my lord, given to the respondent number 12, my lord, to start the, my lord, is weekly, my lord. So we are the person, my lord, we have an agricultural land, my lord, and if it is going to be established, my lord, then it will, my lord, whole, my lord, to entire land will damage, my lord. There's a report also about our agricultural officer also, my lord. And moreover, it is one within the, my lord, eco-sensitive zone. The Supreme Court, my lord, that normal cases stated, my lord, if it's within that eco-sensitive zone, then, my lord, in that case, my lord, economy will be given one kilometer. But if beyond 1 kilometer, my lord, if there is industry, my lord, that should be stopped, my lord. But without considering all these aspects, my lord, this impunity order has been passed. And they have no, the 2000 order may kindly be seen, my lord, specifically stated, my lord, that this, before passing the order, my lord, kindly see that order, my lord. Page, my lord. Page 150, my lord, relevant page 153.
Standing order is to seize mobile.
Sorry, very sorry, very sorry. Very sorry.
Who are you?
We had a person, my lord, we are agricultural, my lord, that agricultural, my day going to establish, my lord, that brick lane, my lord.
No, no.
Kindly see, my lord.
On your land.
Not our land, my lord. In our land is surrounded, brick lane is surrounded by our land, my lord. Kindly see, my lord, that is a 154, my lord. Kindly see. 154, my lord, page 154. Kindly see, my lord. That is for ready reference. The relevant paragraph of the joint affidavit are extracted here. That the applicants respectfully submit that the Deputy Commissioner Morigaon may be directed to decide as to whether the brick lane in the name of so and so should be allowed to run and whether the same will affect the applicant appellant surrounding land of the environment. The Deputy Commissioner Morigaon, while deciding the issue, shall take into consideration the report of the Pollution Control Board, Agriculture Officer, and Forest Official expressed that applicant respectfully submits that all the concerned officials of the Pollution Control Board, Agriculture Officer, and Forest Officer should give their respective report disclosing the scientific basis of such report. That the applicant respectfully submit that the Deputy Commissioner Morigaon may be directed to decide the issue after hearing the appellant and the private reference number 132. That the applicant respectfully submit that the Deputy Commissioner Morigaon may be directed to decide the matter within 20. That a joint application that is so filed by the party is taken on record. We approve the terms and conditions as agreed upon by the party towards the facilitating the Deputy Commissioner Morigaon to reach a decision on the matter with regard to the fate of brick lane after considering the report of the stakeholder mentioned in the joint appeal and after approaching of the hearing to the appellant. But without, my lord, taking to consider calling for a report of the this, my lord, official, my lord, the Deputy Commissioner, my lord, passed an order 19 to 2024 on the basis of the order by the Deputy Agriculture Officer 2008, my lord. Can you see that impugn what the impugn has been stated, my lord? The impugn can you see, lord?
No, this, your impute order is 19 to 24.
Yes, my lord.
This is passed pursuant to the orders of the court.
Yes, my lord. After passing of this order, my lord, that NOC has their NOC rejected, my lord. They my respondent 12 file a REIT application. And that application, my lord, or this honorable court pass an order before passing the order by Deputy Commissioner to take into consideration of the order passed by in a REIT appeal, my lord. But they have not taken into consideration REIT appeal, my lord, without straightway, my lord, on the basis of that order passed in 2008, my lord, by the District Agriculture Officer, my lord, the impugn order has been passed. Can you see the impugn order, my lord? If these or they, my lord, if that Deputy Commissioner have my taken into consideration these people, I have nothing to say. Can you see the impugn order, my lord, that 170, my lord? $169, my lord.
Yeah.
That's the impugn order. Can you see?
The industrial class.
No, you know, subsequently classified, my lord. Subsequently classified, my lord. They're not industrial land, my lord. They're agricultural, my lord. I can file an application, my lord, if necessary, my lord. File a affidavit, my lord. It's not, my lord, agricultural.
In the order, my lord, it is clearly stated, lordship, my lord, it is industrial class.
After passing of the order, my lord, first REIT appeal, my lord, 2012, my lord, then they classify the industrial land. Before it was the industrial land, my lord. Bound, my lord. Order has been sought for, my lord, in 2012, my lord.
You were not hurt by the DC.
No, I have been heard, my lord, but I have been heard, my lord, but DC has not taken also report of these officers, my lord.
Which of
This, my lord, that district agriculture officer, pollution control board, and DFO. And DFO, wrote, DFO, what the DFO said? DFO, they say, no, ecosystem has not been finalized. In that case, my lord, Supreme Court judgment has said, my lord, if ecosystem has not been finalized, in that case, my lord, 10 kilometer radius should be declared as eco-sensitive zone. The proposal has been submitted, my lord, that has not been finalized. And kindly see, my they have taken into consideration of this agriculture officer 2008 report. Subsequently, there are two reports in 2012 and 2013. And that two reports, agriculture officer said, my lord, if allowed to, my lord, this weekly allowed to establish, then entire land will be, my lord, environment will be affected, my lord. These two reports have not been taken into consideration.
Yes. So who appears for the state?
And
What
for
is
the respond number 3 and 4.
Yes, what I
What is that? I pay for some time. I will not receiving. We already been communicated.
all the parties are represented.
Lordship.
Yes, yes, sir.
I have served a copy of my affidavit. I'll leave to it.
But, but, the thing appears to be
Respond 3 and 4. Okay.
Respond 12.
well, the Tripura board,
Respond number 5 Lordship.
I,
One.
one, and even else, pollution control.
It's Borua, S. Borua.
Is Borua. 8, 9, 10. And for the Union of India. See. Yes, right. The respondents are direct by the company. 3 weeks time. By
Also fix a date, my lord. Can it be on June, my lord?
June 24th. 24th.
Okay.
24th June.
Right, lordship.
Hello, you lost my kindly see the last order dated 3/5/2024. Order dated 3/5/2024.
Yes.
Oh, my lord, they can seize the goods, but they cannot seize the immovable property, movable property, immovable property.
Where is the improved order?
There is no such improved order, my lord. They only says they recover the gold, they are goods, and arrested the persons who are my tenants, my lords. All good they says and taken. But thereafter they sealed all entire my house, my lord. They sealed. They cannot do it, my lord.
If I is taken in this case, the house which is under locality of the department, the tenanted premises of the petitioner.
Yes.
And that was raided, and from here, 217 pieces of gold was recovered. Some person were arrested, and the house was kept under seal of the department for investigation. Now I have to obtain instruction. Investigation is complete. Notice was issued. Someone was issued to the petitioner, but still in town now.
No,
And they are waiting that the petitioner come and they will hand over the PL other to the petitioner.
Because there's someone I appeared. My statement has been recorded. So this is it. I have
Now we don't for the purpose of investigation.
Where is the notice?
number
Page
annexer 1, man.
Page 17.
Page 17.
Annexure 1 is the summon.
Someone, this is that.
Then subsequently some other notice.
No.
Proxy for my instruction, she was called. And, over telephone by the department.
Why will it come?
To hand over the keys and other to the petitioner.
Why will it come like? You issue a notice.
And for as of now, Lordship, we are not required the premises because in this
Record it, you issue proper notice and hand over the.
Lordship.
Third learning council. By the action of the responsible authority, more particularly which authority?
The DRI. That's number 2.
The respondent number. The respondents to be
Yes.
Not.
it keeping the tenanted premises of the litigation. Wait. Sort of that measuring of that by 5.97 and below what in terms of our rectification for the see the complete house. Right. Bedroom, all the kitchen. So, the house was set up at with the effect of money 2023 at a rate there is an agreement to finalize
The agreement not done because there is some defect.
not be registered. The responsibility is for so there will be rated and 17 full with of foreign origin. Way 36 elevated 5 and Indian currency notes is 13,20 35 6 and 25 of Wi-Fi. Here I should listed all the and Panchanama after completing the service, needed see the application. There was the search and on which date?
On 14/3/2024.
and perpetuate so that or the statement submitted that petitioner there is no allegation and the what the item C or there is however fine having already yeah then council then DNI that
No, offense yet to be filed. Investigation is offense report is to be filed after taking approval from the.
have yeah right.
Within 24 hours.
But if affidavit copy has been served today, my lord, in the court. My lord, I will file
What
affidavit.
No,
My lord, affidavit.
affidavit in opposition filed today, my lord, day, my lord, in Response number
you are
5. So matter, my lord, 2 weeks, my lord. There is urgency, my lord.
Hold
Me pleasure, Lordship. Lordship, we have already taken a step, my lord.
Good. Sorry.
Step.
You have taken
Yes, my lord.
when
9/5/2024, my lord. But we have not received any reply from the respondent.
ID card on respect of what debate. You are appearing.
Lordship,
What
respondent,
what type?
respondent number 4 has superannuated, Lordship.
You are representing anyone? Are you
No, Lordship.
representing anyone?
Till now, we have not filed our wakalat claim.
You be understand. Effort for. Maybe. What is there in the
Lordship, writ petition is for, they were agreed, because land acquisition, Lord. Till now, no acquisition has been done. Lord.
there is, right? And responded fine.
Published.
Item 50.
I'm for the petitioner, my lord.
Yes.
My lord, amendment petition is pending, my lord, 2597. With a prayer to allow certain amendment in the main petition. My lord, I may kindly be allowed to include a prayer for compensation of rupees 5 crore and may also kindly be allowed to file additional affidavit as proof of premise. My lord, in the array of name of parties, my lord, name of respondent now 2 to 5 may kindly be allowed to be changed by making the.
Yes. Any objection?
My lord,
No objection has been filed, my lord, till.
it's my lord, last opposition, there is a observation that, well, I am appealing for the chairman of the State Bank of India, my lord, to add my misstatement, which was I have filed in the 2023, my lord. I will look into the last orders, my lord. My lord, I am filing this miscase for deletion of the respondent number 3, my lord. It's because, my lord, the chairman, my lord, has nothing to do in this case, my lord.
However, let the amendment be there first.
Yes, my lord.
Are you objecting to the amendment?
No, my lord.
Lord, I appear for respondent number 5. CIBL, ma'am.
Huh?
TransUnion CIBL, ma'am.
Civil, my lord.
Civil.
Civil.
Yes, ma'am.
Yes.
Lord, perhaps before allowing the amendment, my lord, if my lord, maintainability may be, my lord, gone into, my lord, because he has thought, my lord, he will
File
compensate.
your objection. You don't file your objection.
I have not filed.
Then you're objecting to amendment. You file your
Here is the
It was filed in 28th of August 2023, my lord.
Why file the
My lord, 5 minutes may kindly be allowed. My lord, I'm a contractor. I was entrusted with the construction of 2 routes and the work value is 5 crore. Construction to be completed within 9 months and maintenance work for 5 years. My lord, in September, I was asked by respondent for round 4 to take a credit card having value of 7 to 10 lakh. I asked them to send the terms and conditions. But my lord, when I obtained the envelope, I obtained a credit card having value of rupees 20,000. I asked them to cancel the credit card, but they did not cancel and take fees of rupees 3,166 from me, but it was not my consent to the card. But my lord, they have wrongly sent information to the civil that I have arrear. As a result, my civil score on 30th of January 2023 fell. My lord. And bank has I applied for loan from the bank to release loan to for construction work. And I'm also a MSME entrepreneur. I have lots of investment, my lord. As my civil score get down, my lord, bank stopped to release my loan. As a result, I suffered badly, my lord.
Is there a authority to decide on applications regarding?
I have to take a private finance at high rate of interest, my lord.
My lord, civil is a different, my lord, here is a case, my lord, civil department and that, my lord, credit card department and SBI. These are 3 companies, company registered under company act, my lord. There's a, every company has a separate domain, my lord.
Here is a case, my lord, why I am filing this miscase, my lord. He made a party to the chairman of the state bank as because we are a holding party, holding company, my lord. And respondent number 4 and 5 is a subsidiary company. In these petitions, my lord, not a single line is written against the chairman, my lord. If suppose, my lord, if any relief is sought from the chairman, that is another aspect.
I
That
can,
is why
I can reply, my
Let
lord,
me
that, এক minute. SBI is responsible. Why, my lord, SBI is responsible? SBI and SBI card, two separate company, no doubt. SBI is a statutory corporation filed by central government and State Bank of India is a company incorporated and under Companies Act. It is a public company, my lord. My lord, chairman of the State Bank of India is appointed as the chairman of State Bank of India, respondent number 4, State Bank of India card.
What exactly your prayer?
My prayer in the petition is to cancel the credit card. After cancellation of the credit card, to publish my new civil score, and my lord, to stay the proceeding in ombudsman if any award is passed, to set it aside because it has no jurisdiction. And in the amendment,
Your credit card,
I don't know, my lord. It is their business, my lord. My lord, actually, I did not. Yes, my lord, that is one of the fact. I filed representation before the competent authority.
Ombudsman is a party, my lord. Ombudsman is a party here.
Yes, yes, that means. At the first instance, I filed representation before all the competent authority, my lord. It is necessary to file any petition before ombudsman, like writ petition, my lord. But Reserve Bank of India, Governor Reserve Bank of India himself sent the petition to ombudsman. But in the integrated ombudsman scheme, it is specifically stated that only the petitioner can file the petition and it must be addressed to the ombudsman and no other person can file. There is a special format for filing. And no, my lord, if one is filed, then new petition cannot be filed. And moreover, their jurisdiction is very less.
what the report of
Yes, my lord, it is a read petition. State Bank of India Card and Private Services Limited is also a state. I can prove it, my lord. My lord, under its jurisdiction, it is covered, my lord. My lord, there is violation of legal duty because under when State Bank of India.
contract, you apply, they offer to accept it, now you give it back by legal.
No, my lord, I did not apply, my lord.
Then how did that come?
My lord, they offered me, but I have not asked them to send the card. I asked them to send the terms and condition. If the terms and conditions suit me, I shall then apply. I told them, my lord.
I don't think we, as a report, we will get into this controversy. You have other.
My lord, nothing exists now, my lord.
Why? Why nothing?
My lord, because ombudsman, without having any jurisdiction, have taken cognizance of the case. That is why here one prayer is also made.
What orders have the ombudsman passed?
I don't know, my lord.
You go and find out. How can you know? Unless
Because
you go and find
because my lord, it is because my lord, I have not filed any petition before ombudsman. It is necessary. It is necessary to file by myself and have to address to the ombudsman directly. And my lord, respondent number 4 is a state. I can prove it now, my lord. And there is violation of legal duty by respondent number 4.
How respondent 4 is the state?
My lord, I have memorandum an article of association of the respondent number 4. I would like to place before this honorable court today.
Well, this is for orders.
Well, perhaps for response number 4, sir, this is not complete for response number 4. SBI cards.
But you are referring to.
See, my lord, I am thinking, and had this, if that case is regards of the mandatory also, I have in the written in that is not covered as definition of state under Article 12, my lord. This case, my lord, that is why, my lord, my prayer is, my lord, kindly heart my miscase, my lord. And because chairman has made a party of the State Bank of India, is nothing to do in this particular case.
My lord, I can prove that State Bank of India
Let him prove that how the chairman
Yes,
is
I can
involved in
argue.
this case, my
I can
lord.
argue.
For my lord.
I can argue. I can argue also that as State Bank of India Trident Payment Services Limited is a state. My lords, first of all, my lord,
We keep it for a hearing date to argue.
yes, my lord.
My prayer is, my lord, miscase kindly may have
Take up
one-
everything, all meet.
My lord, a speaking order may kindly be given that it is fixed for hearing regarding it is state and maintenance.
Yeah,
my miscase also, my
but
lord.
your service or responded for is not.
No, no, my lord. All services are completed. There is office note from the honorable registry. Yes, my lord. All services are completed, my lord.
His grievance against the respondent number 4, my lord.
No, I can prove that responsibility.
As per office note 5/6,
Service is completed. my lord.
did not respond to that. However, not it is. Sir,
Yes, your lordship. 3, your lordship.
you are appearing for 3.
3 is your lordship.
Who's for 4?
Nobody is appearing, my lord.
My lord, 2, 4, and 6 has not appeared.
However, not here. Council, for
My lord, these two documents may kindly be regarded as part of the record, memorandum and judgment.
After vacation.
admission here. On 20.
20.
My lord,
20 June.
20. My lord, my miscase will be had on that day, my lord.
my lord, that may kindly be
That
again.
may be observation, my
All-
lord.
all IAs will also be posted. Taken up on
My lord, date
20
June, 20
June, my lord.
June.
Publish it.
You can take back this, you give it to us on the next date fixed.
My lord.
Yes, everything.
In this case, I am we have filed an affidavit, lordship. There is a office, that lordship. Notice upon the private respondent has not, any card has not been returned back, lord. Test was taken.
Private service of respondent.
5 and 6.
I am for 2 and 3.
Or
2 and 3.
Uh-huh.
Can it? Obliging.
Actually, Your Lord. My lord, regarding service, my lord, I think my completed because there is an order of the Lojima Court, my lord. In respect of respondent number, my lord, 1 and 2. And other already, my lord, appeared.
the
And
IA or writ petition?
IA.
Yeah,
IA for my lord, condonation of delay, preparing the restoration petition. my lord.
service complete or respond. For the other respondent.
With Deputy Commissioner Gail. Yes, I am appealing for 4, 5. I am appealing for 4 and 5.
4 and 5.
So almost of them all are completed. Their delay, what they have stated in the, this is already dismissed for default 3 years back, 2 years back. Now they have come with a certain plea which they have not given sufficient cause. Why there is delay? And this absolutely comes to a conclusion that court has already in writ petition, main writ petition, that this court has no, case has no merit. After that, they didn't appear.
No, my lord, my writ petition was dismissed for default, my lord.
After
And
they,
before-
they, because interlocutory
IA
application,
IA, my lord, there is order, my lord.
But I,
But they have filed an IA for vacation of the interim order in the writ petition. I have filed for
so they have,
restoration.
in that order, if you also go through that, they have annexed it.
I have
everything
listed the reason,
discussed.
my lord. Why
So
I-
nothing remains. This simply wasting of time on this court.
No, my lord, it may
Not only that,
adversely affect my compensation.
and no sufficient
because I
cause has been
taken-
shown in their contention delay petition.
Let them file a, my lord.
Already I filed an objection.
Copy one.
Copy to one, I
Not issued any. They have not filed any objection. my lord.
already filed. On record is there.
Copy one.
What is your demand here?
My lord, read petition, my lord, my grievance is, my lord, my lord, this company, my lord, taken a scheme for my lord, this pipe, my lord. So my grievance was, it will be in the, my lord, west side, my lord. My lord, there is side, my lord. It's my lord, side is western side. my lord. So, my lord, so that grievance remain, my lord.
What?
In the meantime, my
You are
lord,
asking for compensation.
no, my lord.
Yes.
My lord, this pipeline, which was there, my lord, as per project, my lord, it should be on western side. my lord. But they have, my lord, taken, still not completed, my lord. They have taken, my lord, in other side, my lord, which is not as per project, my lord. How?
No, no,
My lord,
how? Well,
lordship. There is a authority, my lord.
But how does it affect western side?
My lord, that side, my lord, if he, that side covered, my land will be covered, my private land will be covered. That's it.
Then if you also go to the page 19 of their application, you will find the judgment.
And
What
my
they are allowed, this Honorable Court has, whatever grounds they have taken, already answered in this, already. In page 19 of the judgment of their, of the earlier IA,
The current I.
current IA,
890.
page 19.
But this order was passed in IA, my lord. They have filed for vacating this stay.
No.
So this is not final order.
Already, the already objection they have raised in the repeater already answered. In page IA, para 7. If you have to go through that para 7, you will find the answer.
So, have you, has the pipeline been laid down?
Only later, only.
What do you mean?
No, this,
No, my lord, as per instruction, not still not complete.
Not late.
Not late, my lord.
which one? In this part, no, not let down.
What were you doing? If the interim order was vacated?
Yes. I think the matter, because already pipeline already started and the Prime Minister has already commissioned that.
No, you're not clear on it. Get your
As per my instruction, my lord.
This the instruction have to take, because whether pipeline,
My
whether
lord,
or
let
not.
them supply.
The most obvious instruction.
Because what they are, only interim matter of vacated, there are no grounds to for.
Their interim order is vacated,
Yes.
have you proceeded with the work or not?
That instruction I have to take.
That is the crucial
Yes,
instruction.
the instruction. If already laid down,
And my lord,
I filed with restoration.
জানি না কেন বলি না কে বলে পাইপলাইন চলে গেলে Prime Minister উঠে
By
my lord, order date is specified.
this is the petition for condonation.
Condonation. Preparing the
Petition for
restoration
the
bid.
condonation of delay of 3578. Filing the restoration, accompanying restoration. For restoration of WPT number. Dismissed for not.
On my lord, 3/1/2000.
The delay in filing the restoration has been presented as the part 7 days. The grounds for delay has been specified. Like, there are the responses by the petition. That delay of not- Right. That by order date 6/2020. Passed in the I court had court has made that dated the date. Very made by whether the respondent have proceeded date of the pipeline. The date of the pipeline is 20 or over, then the council, like obtain the instruction.
in the meantime, if the pipeline is laying down, still the work is going on, then this pendency will not bar them from laying down the pipeline, because
The
My lord, objection copy may be separate. I have not.
no, objection copy, I think
and be listed after the weeks. Get
All right.
instructions that
No, I will get it, sir, but in that, I don't know, if it is laying down, we are under process.
before you get your instructions, then place it before the court.
Yes. Interim packet আছে ওখানে করতে পারবো
May I please?
Yes.
Lordship, this IA is for the substitution of. Okay. During pendency of the, next case, my lord, the respondent number 5, my lord, the expired, my lord.
Respondent 5.
Respondent number 5 expired, my lord. This honorable court allowed to file the substitute.
Profullo Malakar.
Yes, yes, my lord.
Who expired?
Lordship, Prabhat Chandra Malakar. Prabhat Chandra Malakar expired, my lord.
Petition. 5. Yes, any objections?
The private respondent law.
Aye. Aye. Form. Aye. State that expired. You represented number 5.
No, my lord.
The petitioner.
I am the petitioner, my lord.
What is your claim against respondent 5?
Uh, Respondent number 5 is the necessary party, my lord. In the expedition.
Well played. Left. Well played. Yes. Subject. Respond 5. Aye. 5. No. 5. 5. Alien. Where I am
Lordship, Profumo Malakar and Bharati Malakar.
Profundo Malakar. Maybe the son in law. Was representing respondent 5.
Lordship, he was not representing my lord as per order dated my lord, Lamajima court order dated my lord, 22 to 2024, my lord. Page number 22, my lord. In regard to the notice issued by registered post with AD, it appears that notice in respect of respondent number 5 has been received back with the postal remarks addressee expired and RT has. It is not served, my lord.
Five and 6. Steps of right. left.
Yes, my
File
lordship.
for order.
Yes, my lordship. My lordship, one IA, 1174, IA civil, 117424 in WPC 148124. Had filed, had done filed before the honorable court, my lordship, rate for implement of Pallavi Mandal, the national mother of baby Uday Sarkar, as respondent number 7. And as per application on 26 April 2024, the honorable court had allowed a matter of implement. Now, my lordship,
Yes.
Please, maybe necessary order for further step, my lordship. And
I, yes, I earlier ordered it in 4 past it, IA 17. At that. Have you filed the?
an interim, my lordship, your lordship, may further be pleased to allow the interim custody of the baby to the petitioner's adoptive parent until disposal of the instant petition, my lordship.
Let me.
Because
serve.
actual fact.
Serve. Where is the amended post title? Have you filed amended post title?
Yes, my lordship.
Not listed.
Okay. Huh?
I.
Amended post title is not here.
I will.
You have filed the.
Post title. My petition was petition table 1481/24. Actually, my lordship, the baby is depriving her from.
First to array the party, you have been given an order in the IA.
Yes, my lordship.
Yes, by which the natural mother is to be arrayed as party respondent number
Yes,
7.
Yes, my lordship.
But you have not filed amended post title.
Further, and I have not gave any order for amendment petition, madam. I want a further order to take necessary step, my lordship.
In terms of earlier order dated 2024, party I the prayer of the repetition receiving implement of 1/4 of the bundle stated to be the natural mother of the baby sought to be adopted by the applicants. For the where the repetition is permitted and the court permitted the natural mother be arrayed in order number 7 in the PPC 1481. Of the I was reportedly allowed and disposed of in the PPC 1481. Pursuant to the order of the first PI permitting the registry to impede all the model. The petitioner was directed to file amended post type in the registry. In terms of the order passed I by impeding all of the model is 7. From the case record, it seems that complete set of amended post title perhaps has not been filed by the therefore petitioner is granted 2 weeks further time file amended post title before the registry.
Yes, my lord.
And the matter be thereafter listed. To file amended post title
Yes, my lord.
within 2 weeks.
Yeah, my lord. Okay, my lord. Obliged, my lord.
Yes, please, your lordship. But in this case, the original writ petition was expired. So we have received the details of legal heirs and we have to file substantial petition at some time.
What is the claim here?
Here, my lord, the name of the petitioner was cancelled from the land record. And the private
When
restaurant
did he expire?
expired, my lord. On 22/9/2022.
Already.
So we have to file delay.
Don't know what. Submitted by the government that had expired and on
On 22/9/2022.
9. Prayer made prayer is not objected by
All right.
May I please, your lordship? The office know, my lord, your lordship's order 2524. Wherein my lord register was directed to provide with the GR case number 5023 of 5 criminal work. From the record, it reveals that the record has not come, my lord.
No, Lord, the culture has not been distributed.
There's an office note now,
But
29/5.
29/5.
No,
no.
Sure.
From the register, man. Deputy registrar was directed.
Here.
5023. Right. I saw.
Yes,
Yes, is there.
Recently, perhaps.
Then a date may be fixed, my lord.
What recently? 29/5.
29.
Today,
Yes, sir.
today is 18th.
Huh?
Today is 20.
In the morning,
Recently,
it was not.
in the morning, Lord,
It was not there.
Oh, in the morning
You
it has.
submitted the TLCR. For by year already. The CDM appointment. HCRO CR case number 50. And profile. According to the Learned Council, raised for some time with the records.
On 11th June, Tuesday.
13.
Oh,
It's not 13.
13.
Lord,